morning, everyone. Today is March 19th. The time is now 9:10, and we will call the special magistrate for the town of Pembroke Park. Before we begin, I will be reading an opening statement which will govern these proceedings. I do thank you for your patience and your indulgence. Ladies and gentlemen, welcome and thank you for being here today. Please turn off all cellular telephones to avoid interrupting these proceedings. There are no weapons of any kind permitted in these chambers or anywhere within the facilities. In all issues that may come before the special master, we ask that everyone show mutual respect to one another by listening quietly to each person speaking, and that everyone refrain from any clapping, heckling, or verbal outbursts in favor or in opposition to a speaker. These are hearings conducted by a special magistrate. That is me. My name is Andre McKinney. The purpose of which is to give any alleged violators the opportunity to contest the decision of the code enforcement officer, which resulted in the issuance of a civil violation notice. These hearings are conducted in a quasi-judicial manner, and I am the special magistrate assigned to hear today's cases. My responsibility is to act much like a judge, and that is to hear cases presented by the code enforcement officers and to hear contradictory arguments presented by the alleged violator. These hearings are open to the public. It is required that all persons who testify as to the facts of the case be placed under oath. This includes the code enforcement officer. These hearings will not be conducted in accordance with formal rules relating to evidence and witness. Any relevant evidence will be admitted if I find it to be competent and reliable, regardless of the existence of any common law or statutory rule to the contrary. All documentary evidence must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or a code enforcement officer submits a copy for the hearing file. Each party shall have the right to call witnesses and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination, to impeach any witness, regardless of which party called him or her first to testify, and to rebut the evidence against him or her. It is my responsibility to make findings of fact on the evidence of record. The fact-finding determinations of a special magistrate are limited to whether the alleged violation occurred, and if so, whether the person named in the civil violation notice can be held responsible for that violation. I may also modify the decision of the code enforcement officer as to the time for correction contained in the civil violation notice, even though said time is rebuttably presumed to have been reasonable. I have the authority to assess and order the payment of civil penalties, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code enforcement officer's decision, I must find that there is substantial, competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged. If I affirm the decision of the code inspector, my order will specify the amount of the civil penalty, the administrative cost of the hearing of not less than $100 if assessed, and the date by which the violation must be corrected to prevent resumption of continuing violation penalties, if any. An aggrieved party, including the town, may appeal a final order of a special magistrate to the Circuit Court of Appeals. Such appeal shall not be a hearing de novo, but shall be limited to appellate review of the record that is created before the special magistrate. An appeal shall be filed within 30 calendar days of the issuance of the order sought to be overturned. If you are found guilty of a civil violation as charged, you will be assessed an administrative fee of $100. The city representative will present their case first, and the alleged violator will present their case thereafter. I will consider all evidence and render a decision after all arguments are heard. All those who intend on testifying in today's hearing, if you are able to do so, please stand and raise your right hand. If you intend on coming to this lectern and testifying, please stand and raise your right hand. Do you swear and affirm that the testimony you'll provide is the truth and nothing but the truth? Okay. You can have a seat. We can begin. Thank you.
Okay, we'll do roll call. Joseline Ramirez, Chief Co-Compliance Officer, present.
Brian Sherman, Assistant Town Attorney.
Andre McKinney, Special Magistrate.
Aymara Fontalva, Code Compliance Clerk.
Code Officer Gene Gusson, Town of Pembroke Park.
Okay. And then we'll do the adoption of minutes. We're presenting the minutes for the February 19, 2025 hearing.
Moved as presented, no changes?
No.
Okay, the minutes are accepted.
And item number 5, adoptions of agenda, deferrals, additions, and modifications. We have 5 changes. Item 5.1, case 663, removed from agenda. Property owner is approved for amnesty program. Item 5.2, case 744, removed from agenda due to clerical error. Item number 5.3, case 8305, removed from item 8.7 to confirm fine and added to item 10.1 for an extension of time. Item 5.4, case 1359, removed from agenda. Respondent complied before hearing date. Item 5.5, case 10638, removed from agenda. Respondent complied before hearing date.
The agenda is accepted as modified with additions, modifications, and deferrals. No objection for the record. Next item.
Okay, we will proceed with the cases in the order the people arrived, unless there is any attorney present. Okay, so we'll hear your case first, okay? Your name is Lourdes?
Yes,
Okay.
good morning, Your Honor. My name is Lourdes. I'm here on behalf of 3101 Realty Corp.
What item is that on the agenda?
1 moment.
9.1 and 9.3.
Thank you. 457.
This is Attorney Lourdes.
It's case number 6382 3101 Realty Corp. at 3101 West Hallandale Beach Boulevard. This is for hearing to abate fine. So is the next case 7457, located at 3127 West Hallandale Beach Boulevard.
Okay, so I'll present both cases and then they can say. All right. Chief Co-Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 6382, property owner 3101 Realty Corp., site address 3101 West Hallandale Beach Boulevard. A notice of hearing to abate fine was sent by certified mail, February 28, 2025, posted to the property March 6, 2025, posted to Town Hall March 7, 2025. This particular case, we're reducing it by 95% because we had, we're reducing the fine of $204,350 by 95% because at the time we had a personal there and they were supposed to take care of the application and that person is no longer here with us and we can't seem to find any document to the compliance of the case. So to give more relief to the owner because they did try to comply earlier on. However, since we don't have that personal here employed at the time, we can't verify that information and that's why we're giving extra relief. So the amount that we're going to reduce it to is $10,313.
Just for clarification, for the record, is the property in compliance?
The property is in compliance.
Okay. Okay.
Well, this case, is it this property or the other cases for other properties?
Repeat the question.
Well, we know that there's multiple cases with 3101 Realty Corp., but this one is in compliance. But are the other cases located at this property or other properties?
Are you talking about the cases that are not under agenda?
Correct.
They're related to the property.
Okay. So, Ms. McKinney, there are other cases related to the property that are out there, but this one is in compliance, and the town is willing to, again, make the offer and move forward as to the reduction of fine on this particular case. We're having discussions with council that there might be other opportunities to help resolve those cases, and that may be presented to the magistrate at the next hearing. We need to speak with the town manager, who is unavailable, but we're working out those to see what we can do to assist and facilitate with that situation.
And it looks like based on the citation or the violation for this particular case, case number 632, pertaining to a special events permit?
Yes.
Okay. Good morning.
Morning.
If you could please state your name for the record and who you are in relation to the subject property.
Luis Guerrero, I'm the property manager.
Okay, and you're here with the owner's authorization to
Yes.
speak? Okay, and I heard you say your name Lourdes earlier. You're an attorney. Okay, will it be Luis or will it be you presenting?
I mean, I just want to say a few words, and then Louis
Okay.
will be here as a witness, and he's also been dealing with the city on all these matters. My name, again, is Lourdes Abalia. I do represent
You can move the,
My name is Lourdes Abalia. I represent the owner of the property, 3101 Realty Corp.
okay.
Thank you for having me.
Thank you for being here.
On behalf of the owner, and he apologizes he can't be here. He's going into surgery in the next week, so he's in a lot of pain. But he is asking to please consider bringing down the fines to zero. He has been working alongside Louis to try to work on these issues. And again, as she stated, the person that they were dealing with is no longer here. And Louis can explain a little bit better as to what has been going on with this special event permit that was needed. Again, the owner didn't know that apparently a tent was put out. They never asked for permission. The tenant never asked for permission. It was done, obviously, without him knowing, and they've been trying to remedy as soon as they found out what was happening.
Yeah, this happened about 2 years ago, I believe, that we brought in the permit special event application. After the fact, we brought it in. There was a lady by the name of Lisa working at the time here.
Okay.
I gave it to her. I signed it, gave it to her. But I think I paid the fee. But I don't. She's no longer here. I forgot. I gave them the application. You know, I thought it was gonna get approved, and that's it. It's over. Come to find out, how many years? About 2 years later, there's $204,000, and I'm like, we didn't know. We simply didn't know. So it's out of mind. We brought the application in, paid the fee, and that was it. We come to find just $204,000 here. Why are we responsible for paying $10,000 when we brought the application in?
I understand. So what I'm also hearing, correct me if I'm wrong, is that you were never notified following submitting the application?
No.
Either side. Officer Ramirez or town attorney, they're asking for a mitigation down to zero. Is there an objection?
It's
What's the
your
town's position?
our position is a 95%. We normally don't do that type of reduction. I try to search our records to get some sort of evidence that there was an application submitted. However, I could not find any type of records. So there's no receipts, there's no evidence of that this took place, this conversation. The only thing is that I only have a recollection of him coming in and speaking to Lisa, the business tax clerk at the time. That's all I have recollection of. However, I don't have any evidence of the application or receipt or payment.
Okay. There's no documentation to corroborate, is what I'm hearing
Correct.
from you or the city,
Correct.
or the town, rather.
Yeah.
This is a commercial property. As the officer has testified, it's not the normal, the 95% is not what's usually accorded commercial property. But I have a couple of questions just to gain more clarity. You dropped off the application, so that signal that you knew an application of sorts had to be submitted. Did you follow up on it at all?
No, I did not. I brought it because that's all they required. Bring the application in, it gets approved, you pay the fee, and
Has this property or property owner or you yourself, have you ever applied for a tenant in any other not tenant, special events in any other instance?
I haven't. I believe the dance studio had at one point had a tent out there for a special event, and also I believe we have another tenant, Body.
Body Elite?
Yeah,
Okay.
I think they had an application that they brought in for a special event also.
Okay.
I'm not going to grant a zero abatement. The mere fact that the town is, and these are my words, giving you the benefit of the doubt because the worker who was here is no longer here. So there may have been some sort of mix up in the paperwork, not sure. But based on the fact that the town is willing to reduce it by 95%, I'm not going to mitigate it down to or abate it down to zero. I will reduce it by an additional $3,000. And that's really based upon the testimony of the town, acknowledging that something probably went awry in this instance. It appears to be an anomaly. And the individual who you provided the information based on what you indicate is no longer here. So that should bring it down to $7,313. This includes the administrative cost?
Yes.
Okay. But consider this probably a one and done, because I've never seen the town do this. So, okay, let's hear the next case, 7457.
Okay.
Within how many days?
Normal, it's 30 days, correct?
Right. Is 30 days acceptable? Do you need me to? Okay.
Now, I do have to tell you that, let me give the oral pronouncement. If that amount is not paid within 30 days, the original amount of $204,350 will resume. Anything else before I give oral
I
pronouncement?
asked for 45, just because we're trying to do a negotiation with, this particular property is currently under contract to sell with Home Depot. And Home Depot's purpose of purchasing is to redevelop the property. And I was speaking with Dave? No. Brian. And we are gonna try to get on a conference call with Home Depot to talk about a couple of other items pertaining to the property, which right now we're set to close April 16th, but if we are gonna be entering into some sort of an agreement with the city and Home Depot, it may take more time. I'm not sure if this is gonna happen by April 16th.
Well,
Town's
Just ask for
position.
45 days.
I'll be honest, I'm inclined not to grant it, but
These cases are independent of our discussions. They're on the docket for today. You're reducing them, so it's up to your order as far as when those would need to be paid. That was the situation I was alluding to earlier. I didn't know if council was prepared to put that information on the record, on public record. Now that she's done so, we were approached, I think it was late Monday, and made aware of the situation as far as not only these cases, but other cases that are out there regarding the sale of the property. So we're going to have discussions with the town manager regarding those open cases as to which are not in compliance, as to see what we can do to assist and to facilitate the sale of the property. In those situations, for other cities, what we've done is what's called a stipulated agreement, where we would agree that the new owner can take the property, the city would release the liens for a payment, and then the new owner would have a certain amount of time to bring those violations into compliance. Now, given the fact that this is a potential redevelopment, it would mean a lot of different things as far as when that time frame would be, and the manager would need to be updated, which we have not yet done, so we don't have the information to. So there's a lot of what ifs on that, but if we're going to assist where we can, help facilitate that. I would take the position that these two cases are on your docket, and if you make a ruling, then we're going to follow that ruling. It's not going to be one or the other. If they want to move forward and pay that in the time frames, that's up to them. Then at that point, it would automatically go back to the full amount. Then at that point, if it becomes a matter of a negotiation between the town and to help facilitate all these cases together, then we would look at all those cases together. So we're not gonna essentially play one against the other. Either you enter your order and then they want to go with that and they want to move forward today on those, and then at that point, and then we'll follow your order. Other than that, if it moves into those negotiations, we'll address that. But they're two separate things, and I don't want to cross the two items.
Right. My thought process is perhaps the abatement hearing was maybe premature. And why I say that is because you're in ongoing negotiations. And oftentimes when there's a pending sale and there's code violations, what I don't think is fair to the town is that this forum is used as a means of some sort of assisting in brokerage, because that's not really the purpose. And this is an old case. So as to the question of 45 days, notwithstanding the negotiations, does the town have an objection to that?
No.
I've already indicated I'm inclined not to. So the town doesn't have an objection. Based on the non-objection, 45 days to pay. Otherwise, it will resume. Let me give oral pronouncement. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for abatement. The property or the violation for case number 6382 is in compliance. The fines are mitigated from $204,350 to $7,313. Respondent is assessed, that includes the assessment. The administrative costs are assessed, but the respondent is given 45 days in which to pay the abated amount. If it is not paid within that time frame, the original amount will resume. Anything else on that case? Okay, we can move on to 7457.
Chief Co-Compliance Officer JOSELINE RAMIREZ for the Town of Pembroke Park, case 7457, property owner 3101 Realty Corp., site address 3127 West Hallandale Beach Boulevard. Notice of formal hearing to abate fine was sent by certified mail February 28, 2025, posted to the property 2025, posted to Town Hall March 7, 2025. It is the town's motion to abate the fine of $181,158.50 and reduce it by 85%. That total amount is $27,308.50. We could round it off to 08. $27,308, and this includes the administrative fees.
Okay. And for the record, if you could just reintroduce yourself for case number 7457, who you are in relation to the subject property.
Good morning. My name is Lourdes Zabalia. I'm the attorney of record for the owner of the property, 3101 Realty Corp.
Good morning. Luis Guerrero, property manager.
Okay. What's your position on this case?
Your Honor, again, with this case, we also asked for a zero penalty or fine. It's my client's position that he did not receive notice of this violation or fine. He owns many properties. As soon as he receives violation notices, he immediately starts working on curing the violations. Again, as I stated earlier on the record, he went under contract to sell this property on October 3rd, 2024. On December 23rd, 2024, we received the lien search from the buyer's counsel stating that there was this violation on the property, and this is the first notice that he received of the violation. Again, the property they were under construction. They were doing some work on the property. So he did tell me that the office is kind of changed. So maybe it was sent to an office during one of the changes and he didn't receive the notice. There's a couple of updates on Sunbiz, and he was telling me that offices have changed on the premises, like their office where they're getting their mail. He ultimately had to change the office to his home in New York.
By the officer's testimony, the record reflects that notice was provided, and notice under Chapter 162, it would be whatever address that the owner had on file. So Sunbiz would not be that. It would be the property appraiser's office. Is there any evidence that supports that the notice sent to the city as reflected on property appraiser was anything other than what property appraiser reflected?
Not aware. I'm not sure.
And I believe the testimony also includes that there was posting on the property. Am I correct, officer?
Correct.
So,
I'll let Louis, because he manages the property. So I'll let him.
When we found, again, we didn't know any of this. When we found out, I came to you. I said, "What's going on with this?" Or I got a notice from you that there was 186 for striping. So we hired somebody to do the striping. We pulled the permit and we fixed it as soon as we knew.
oftentimes, and this is for the benefit of everyone, notice in these contexts, code enforcement and under the law doesn't necessarily equate to your knowledge, right? Because what I'm hearing is that as soon as you found out, but that doesn't negate whether or not notice was actually provided in accordance with the law. And so the record reflects that notice was provided in accordance with Chapter 162. The other thing, this has already been placed on the record, not to get into other cases, but this property seems to be the subject of more than one code enforcement case. So, so that doesn't really provide much of a strong basis for any further reduction than what the town is offering. Certainly not for zero, if that makes sense to you. Is there anything else that you might offer?
Again, if you can contemplate, please reducing at least to 95% or 90%. The 85% is a big hit for him. And from my understanding, Louis has been here multiple times, on behalf of the owner, working on getting everything fixed as swiftly as possible.
Do you have an offer? The city, the town has reduced it to $27,308. Do you have an offer?
I mean, if you can reduce it to the 90 or the 95% of what the fine is.
What's the town's position?
85%.
I reduce it to 25,000. And in this one, you would have to, because the next question is going to be 45 days. Does the town have an objection to?
No.
Okay.
Thank you, Your Honor.
Thank you.
Let me give the oral pronouncement. Based on the testimony and evidence presented, there is substantial and competent evidence to approve a request for abatement. Case number 7457 is in compliance. The fines are mitigated from $181,158.50 to $25,000. This amount, the mitigated amount, must be paid within 45 days or the original fine amount will resume.
Thank you, Your Honor.
Thank you, Your Honor.
Good luck to you. Okay. You ready, please? Oh. So, Nasty would do,
Louis, if you could hold a moment, they'll give you the orders today, okay?
then she didn't tell you.
You gave him a copy?
No. I have to revise them because they were further reduced.
Do you have correction fluid?
No, the amount is written in.
Right. But
Yeah.
Ms. McKinney further reduced it to 7.
Oh, so it was, okay.
Pick it up later.
Yeah. Okay.
I'll stop by and pick it up.
All right.
That's on the record.
Yes, it's
Okay. For both cases, that's on the record. And we've got a room full of witnesses. Okay. Good luck to you.
Okay. Next case on the agenda, 8.3, case 6669. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 6669. Property owner Nerida Flores, site address 3140 West Hallandale Beach Boulevard, lot 232, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail February 21, 2025, posted to the property March 6, 2025, and posted to Town Hall March 7, 2025. Just give me a moment here. It is the town's motion to confirm the fine of $18,700.
Is it in compliance?
No,
And continue to.
and continue.
Well, yeah, because it's not just to confirm that amount, and the fine shall continue to accrue.
And the fine shall continue to occur.
Good morning. Can you please state your name for the record and who you are in relation to the property?
Good morning, Your Honor.
Good morning.
I'm the owner. My name is Nerida Flores.
Okay. Good morning, Ms. Flores. So your case is on to confirm the fine, and what that means is that the property is not in compliance, and so the fines that have been running since they were due to come into compliance, since the fines have run since the date that you were supposed to be in compliance. And as of right now, that fine amount is $18,700. the fines are still running and will continue to run until the property is in compliance.
Okay, I brought the plans and I did the application.
When was that?
I have to
Okay.
search. I don't have it on hand. I requested 3 times already for the inspector to come. The first time I called the inspector, told me that he was not on the schedule to go to inspect. The next one was on October. I emailed Jeffrey. That was when the hurricane was supposed to hit Florida, Miami, or some. But he's like, do you want to change the time frame? I was like, no. If they still coming to my house, then it's fine. I didn't go to work. I stayed all day in the house. No inspector called me. No inspector text me. I emailed again to Jeffrey that day, and I didn't receive any reply. No inspector came. Yesterday, an inspector was supposed to come. Steve, I believe is his name. And all day at home, I have a camera in front of the door, and I called up front, and I don't know the lady name. She mentioned that the Inspector Steve mentioned that he didn't have access to come in my house. I don't have no gate. I live in the mobile homes here in Hallandale, so there's no evidence that he came. I messaged him twice.
You have those messages?
Yes, I do.
And do you have the email that you reference?
Yes.
This is to the town. Does the town reflect scheduled inspections?
This is the first that I hear about this, so it would be something that we have to verify.
Okay.
So, again, she needs to communicate directly with the building department because they're the one who process the permits.
Right.
But this is the first the information has been brought to me.
And Miss Flores, you were calling the inspector to inspect because the work had been completed?
Yes, the work has been, I put up the drywalls already.
Okay. But the purpose of the call to the inspector was for him or her to inspect the completion of the work?
Yes.
Okay. And not for a different matter?
No.
So you understand what I'm asking. If it was a call for them to inspect whatever the work that was done without a permit, inspect that was done and completed so that they could enter in the system that permit is closed, work completed, and there would be a date in the system reflecting this is when the property came into compliance. Was that the purpose of this inspection?
Yes, because I already have a process number. I have the process number is,
When you say process number, is that your permit number that was issued?
yes.
Okay.
That's the only thing that was before the inspection.
Okay, so you did have a permit issued. The person who did the work, if it was you or someone else, they did the work, they completed the work, and your call to the inspector, your first call, your email of October, and then on yesterday, all of these were attempts to have someone come out to examine the work and close out the permit.
Yes.
Okay. Were you able to pull up the message and the email? And if so, please show it first to the officer, and then you can come up and show it to me.
Madam Magistrate, on our system, it reflects that there was an inspection on October 4, 2024, and it failed without penalty. And recently, there's been a scheduled inspection, which was March 17, so it's very recent.
Okay. Is the permit still active?
Yes.
Can I say something?
Yeah.
So the only person that have come is Miss Joseline, and I don't remember the other lady name. That was the only time that someone from the town came inside my house.
Okay. So it looks like, based on the town's record, someone inspected the work, and on October 4th of last year, it failed that inspection.
How would it fail if the inspector never, I have never got inspected in my
What
house.
was the work exactly that was done without a permit?
drywall.
Drywall.
Okay. And that's on the interior?
Yes.
Yes.
Are there any, does the system reflect meeting with the owner?
The system reflects that there was an inspection October 4, 2024. I can look at the comments. One second.
Maybe from the outside.
The comments was that the card was and the plans were not posted in the property. They were not available. The permit card and the plans.
On the outside?
Yes.
And he or she would need that?
Yes.
Okay, so it's a kind of like a technical failure. Is there any record that Ms. Flores was notified of the failure,
No.
the failed inspection?
One moment. I don't know how building sends out their notice. So I can't say for that.
Ms. Flores, were you able to find your communications? Show it to the officer first. Let the record reflect. No, you
Oh,
yeah.
that's the first email. And then the first one was a call.
Okay. Brian, I'm sorry, Attorney Sherman.
Yes, sorry. Okay, so this email though was on the city server?
I didn't check.
Okay, if we can just make sure before we show it to Ms. McKinney that the email is forwarded to you, so it's part of the record, so we don't need to put the phone into
I
evidence.
believe that was sent to Jeffrey. It's not sent to me.
Okay, as long as it's on, it does say, if I can check, it does say J. Lewis at the city email address. So we just got to add it to the case file, just to make sure that it's done, so it's in the record for the file.
Okay.
As we show this
They have to
October
forward
9th,
it to me so I can put it on the
2024
record.
email.
October 25th.
I'm sorry, it's October 9th. I just, we asked to do 14 different things. I just want to make sure that that email is included on the record, like I said, so you don't have to put your phone into evidence. And it needs to be included in this particular case.
And this email was never responded to by Jeffrey?
Yes, I did.
I don't want to, what was, yeah, I don't want to, it's her phone. Right? So did you receive a reply from that email?
Yes.
And
Can you forward that email to Ms. Ramirez at the conclusion of the hearing so we can add it to the file?
Okay.
Thank you.
Yes, the office, okay, that was on 10/10. Yes, the office was closed yesterday in preparation for the storm. We're back open today and the rest of the week. We rescheduled this inspection from last week from today, and it's still on the schedule. Would you like to reschedule this inspection? And I said, thank you for your response. I would like to keep. And then
And by you would like to keep, that's the date of what?
the 10th,
October 10th?
yes.
Okay. The town will need all of the emails. And so from the 10th to yesterday, was there any communication?
Just message, for yesterday's inspection.
So that was the first message you received since October? Your last court?
I call to schedule an inspection.
Because no one came on October 10th?
Yeah, on October 10th.
Why'd you wait so long, from October to March?
Because I had some issues with my daughter. My daughter, she's had autism and she gets injected. So I have to be in hospitals all the time. I'm a single mom. I have to work and
Okay, I understand.
If you want me to, I can, these are text messages I can read into the record.
Please, thank you.
So it's iMessage Monday, 5:10 p.m. Good afternoon, Mr. Steve. I hope you are doing well. I'm writing to confirm the time frame for the inspection scheduled tomorrow at 3120 West Hallandale Beach Boulevard, Lot 232, Hallandale, Florida 33009. The process number is 818428. Thank you in advance and have a wonderful afternoon. Best regards, Nerdia Flores. Yesterday at 4:10 p.m. Good afternoon, Mr. Steve. I'm on your schedule for inspection today. I'm ready to confirm the time frame for inspection scheduled at 3120 West Hallandale Beach Boulevard, Lot 232, Hallandale, Florida 33009. The process number is 818428. Kind regards, Nerdia Flores. That was Inspector Steve, and I can't see the phone number. I'm not going to go through your phone as far as the phone number it was sent to.
So as of right now, your next inspection is when?
I mean, if I go up front, if they could give it to me for Friday, because the lady, she told me at 12.
Okay,
But I was like, I can't miss work today.
I understand. So here's what I'm inclined to do. You have shown due diligence. The evidence submitted in testimony reflects there was an impending hurricane and other life circumstances concerning your child. I'm going to continue this because the question, if the inspection takes place and the property's in compliance, right? The question is, because what I'm hearing you say is that when you first called and reached out for the inspection, everything was done. So the question is going to become, when did you achieve a compliance, right? And so if compliance in fact took place after the date that you were ordered, when was she ordered to come into compliance?
One moment.
If it was after October, let's say if it was November, but if it was before October, you are going to have accrued fines.
September 16, 2024.
Are you following me, Ms. Flores?
Yes.
So I think we can all agree by the testimony, your first contact for the inspection was before, it looks like it was after your date of compliance.
The first one was after I submitted the application.
No, the final order for the code enforcement case, this case, said you were to come into compliance by September, was it 16th? September 16th, the permit was supposed to be closed. It wasn't closed on that date because there were no inspections done on or by that date. Based on the testimony and evidence, the first indication that you provide is October 4th or October 9th, based on what we read. So what I'm saying is, from September 16th to October 9th, you have fines that have accrued. Are you following me? Mm-hmm. As of right now, because there are no inspections, it's $18,700. But you've shown me evidence that, no, I was in compliance sooner than that. I was trying to get inspections. That didn't occur because of all of these things, nature, weather, outside of your control, right? And so what I'm saying that I'm inclined to do is to continue the case at the most next hearing. Now, if you have any fines, it's going to be back before me to confirm whatever amount. I need a date, because you're saying you're in compliance. You've shown evidence that you've been trying to get it scheduled, and I'm accepting that evidence as competent evidence, right?
Yes.
So I'm going to continue the case, but you have to get the property inspected, and if it fails inspection, fines will continue accruing. If it's in compliance, then the date in the system will have to reflect. Now, I'm saying this, I don't know. The town can clarify, and this may be an issue for abatement. Now, if the inspector closes out the permit, that's the date he's going to put in the system. Am I correct? And then you will have to apply for mitigation, setting forth the date that you believe you are in compliance. You can speak to the inspector. They're the experts in that area. but I want you to know you are going to have a set of fines. Okay? The question is, what that settled amount is. And if someone did the work, if you have a witness that can be at the inspection with you when the inspector is there, let's say if you had a contractor who can, speak with the inspector on site to confirm the compliance date when the work was done, that may also be able to assist. Otherwise, your testimony, the evidence that you provided, it's in the hearing file. The weather event, that's documented on both sides, the town and yours. Now, from October 10th to March, you've had issues with your child, which is understandable. You can provide documents and evidence to support that and such, because you have demonstrated that, due diligence in trying to get the inspection. So I'm going to continue your case. I'm not going to confirm the fine. I will give oral pronouncement. This is kind of like the magistrate's own motion to continue. Anything from the town?
No.
Okay. Anything else from you, Ms. Flores?
No.
Okay. I'll give oral pronouncement based on the testimony and evidence presented, on the special magistrate's own accord, based on the testimony and evidence provided. This case number 6669, is continued. You are still under an obligation under the prior order to bring the property in compliance. The fines are still accruing. Okay?
Okay.
Okay, so it's continued for 30 days.
Okay.
So that would be next hearing. So stay on top of this,
Okay.
okay? Good luck to you.
Thank you, Magistrate.
You're welcome.
Thank you, Jocelyn.
You're welcome. Okay. Mhm, I see.
Do you have correction?
Tell him to stay here.
We can do correction tape. Yeah, you're gonna grab.
This is a completely different. Continue.
Why does it say supplemental?
Because we were gonna confirm. That was what we planned.
I don't remember.
She just had them.
No. Oh. Yeah, but we could white out.
But it would
No,
still,
the-
like,
no.
the verbiage would.
What the title would be.
Can someone open the door, please?
The title. We can do correction tape. Might look a little janky.
No, I don't mind doing it, but I also like no. Just so I can get it. I'm not too sure.
I'm sorry.
It's fine. It's fine. It happens.
Okay.
Next case.
All right, next case is on section 7.5 of the agenda. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 9794. Property owner Jean E. and Joel Angervil. Site address 3911 Southwest 52nd Avenue, Unit 8-2, Pembroke Park, Florida. A notice of violation was sent by regular mail July 16, 2024. A notice of formal hearing with a copy of the notice of violation was sent by certified mail February 21, 2025, posted to the property March 6, 2025, posted to Town Hall March 7, 2025. The violations are installation of wooden fence without permit. Item number 2, screen room is stipulated, repair screen room. Both items are not corrected as of February 20, 2025. The town's recommendation is to give 60 days, $100 per diem fine, and $100 admin fee.
Good morning. If you could please state your name for the record and who you are in relation to the subject
Good
property.
morning, how you doing? My name is Eric Angervil.
Okay. So the town's position with regards to this violation is to offer you 60 days to come into compliance, or a fine, a per diem fine of $100 each day will begin accruing. And of course, $100 administrative costs for the hearing.
60 days, you said?
Yes.
Is it 60 days after today or?
60 days from the date of the order. So yes, from today, because I would give oral pronouncement. Today is March 19th. So 60 days from today, everything has to be completed.
What needs to be done, miss, please?
The permit has to be completed and the screen room has to be repaired.
Is there a permit application on file? Has he?
Yeah, I have a permit application on file, but the problem though, I have though, the screen room, what's wrong with the screen room though, man?
It's stipulated. You have to repair the screen mesh.
Okay, once I fix that up, is that okay with you or something?
Right. You have to call for an inspection.
But I already paid some money. I already paid almost like $400 in my own pocket though.
I'm sorry?
I already paid for almost $400 in my own pocket though. Almost $400 though.
And what was the $400 for?
I don't know. From the based on the
Did you pay $400 for a permit?
I already paid almost $400 though
For what?
for the thing that happened or something. I don't know.
No, you haven't paid any fines.
I paid.
But you haven't paid any fines, if that's what you're implying. You haven't told us what you paid $400 for. But you haven't paid anything for code fines or
When I
anything.
was here though, at your office, right? Me and what's his guy name?
Who did you submit payment to?
What's his guy name? Jeffrey, right? Jeffrey, right? I
Mm-hmm. Yes.
paid Jeffrey almost $400.
Then it should be related to your permit.
Okay, then. So I paid Jeffrey for almost $400. I don't know.
Okay.
I don't know what was that $400 was for. I don't know because he told me that it's supposed to be $200 something dollars. When I came here though, he make me pay 400 something. I don't know what was the $400 was for.
It could be, since there's a violation on record, the building department does charge a double permit fee when there's a violation. So it could possibly be that, but I don't know. You don't have any, they should have given you a receipt of what you paid.
Car, I don't
But for,
wanna
but for
Okay.
purposes of this hearing, we're here on the violation. Any issues related to any monies you paid to the town of Pembroke Park, you'd have to go to the permit counter. So for this violation, the town is offering you 60 days to come into compliance. What does that mean? You'll have to have a permit issued. You will have to work within the confines, what the permit allows you to repair. Once the work is done, whether you're doing it or a hired professional, once it's done, you have to call the town to schedule an inspection. Once that inspection is done, if the inspector finds everything passes, they close it out. Whatever date the permit is closed out, that is your compliance date. If it's after 60 days, fines will continue to accrue. Fines would have accrued at $100 per day. Once the property is in compliance from the inspector closing it out, you have to notify the officer, Officer Ramirez, so that she is aware and she can document the code file. Here, this is code enforcement. The building department, they have their own files and their procedures.
Am I gonna pay after I finish the procedure or something?
Okay, so if you come into compliance within 60 days, then no fines will accrue. But if you're not in compliance within 60 days of today's date, each day, $100 a day, it's going to continue adding up until you're in compliance.
Okay. But to me, I don't think it's fair because I paid almost like $400, but for something that the guy told me that it's supposed to be 200 something. To me, it was not fair at all. You know what I mean?
Well,
it wasn't fair at all. I mean,
if
no.
the fee for the permit application, that's pursuant to the town's building department in conjunction with whatever the Florida Building Code, because that's a separate division and department. This is code enforcement. Some violations require by city code and state code permits to be pulled. This is not the venue for discussing permits, what you paid for permits. the question relative for my knowledge to rule on your case is, have you applied for a permit application? And the record reflects you have applied for a permit application. So following, you are encouraged to go to the building department to find out the status of that application, because you're going to need a permit to do the work. And if you have other questions on what needs to actually be done, that would be the time to ask the question.
I don't mind, though. I will follow this, but the problem that I have, though, is the fact that I have to pay $400 in my own pocket, though, for small fence. I mean, it's in the process, right? It's in, you see it in the application, right? For a small fence.
No, I don't have an application or anything.
You don't have the application. Can I go get it in my car? It's in my car. It's right in my car, right here.
I have the permit number.
Yeah. I pay almost $400 for a fence, though. That doesn't make no sense, though. You understand?
No,
That doesn't
I
make no
understand.
sense at all.
I understand what you're saying, but it
And it's not
doesn't.
even-
It doesn't change. It doesn't change the fact that there's a violation.
Yeah, that's what I said.
And
How much the building department charges or the fees for the permit application? This is not the venue to argue that amount, because we're just here on the violation. You can certainly speak to the building department regarding the fee that you paid, but those fees are separate from here. But what I do want you to understand is, if the property is not in compliance,
I get that.
okay,
I get that. But the thing is, though, what I'm concentrating more, why do I have to pay almost $400 for a fence, though?
nobody here can answer that
doesn't make
question
no
because that's
sense,
with the
though.
building department.
I understand, but it's Mr. Ramirez and Jeffrey. Why do I have to pay $400 for a small fence, though? You understand? That doesn't make no sense at all. You understand? That's me. That's the way I feel. You know what I mean?
I
Well,
understand.
almost paying $400 for a fence, though. For a small fence, though. I fix the fence. I do everything I'm supposed to be doing, though. No, that doesn't make no sense, though.
I
I will
understand.
fix it, though. I don't mind fixing it. But why do I have to pay $400 for a small fence? You understand? Would you please explain to me why do I have to pay $400 for a small fence, though?
I've already said no one
Not-
here can
I
answer
mean,
that question.
She's
No.
here, though.
The best explanation is you have a violation. You installed that fence prior to obtaining a permit.
This is what I have
So
to
the
pay
building
$400 for,
department issues penalty fees when that happens. That's just how the
though.
Florida
How long
Building
this thing- How
Code,
long this thing been, though, please?
that's just the Florida Building Code. That's how it's written.
It's not $400 though in the building code.
I don't know their fees, but you will have to speak to the building department regarding the fees.
But it's you, right? Isn't it you?
No.
No.
I'm going to give oral pronouncement and call the meeting back to order. Officer Ramirez, you've already testified. And sir, you've clearly expressed your position with regards to the fees that you paid for the permit application. If you have any discontentment, you have to take that up here. This is a code enforcement hearing. There's a violation on your property. The town is offering you 60 days. You've already indicated you have no objection to bringing the property into compliance.
But I thought that I'm supposed to bring that to you. You know what I mean?
No, I'm here to decide the violation. And if you heard the opening statement, we're here to decide violations, confirm fines, or abate fines. So if nothing else from either side, I'm going to give oral pronouncement. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 60 days or face a $100 daily fine, which shall continue to accrue until the property is in compliance. The respondent is also assessed $100 administrative cost for today's hearing. And you'll receive your order in 1 second.
Jean,
The
can you
clerk-
make a copy of the order?
Thank you, Jean. Thank you. Oh, she's gonna have to, no. She's gotta notarize it.
No, that's not for the fine order.
Oh. you can grab the order on this side, we'll go ahead and call the next case. Good luck to you.
Okay.
The original stays on file.
Next case on section 7.8 on the agenda.
No, she never signs it. Yeah. Here she is, Jean.
Thank you. Chief Co-Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 9850, property owner 2099 South Park Road, LLC, site address 2099 South Park Road, Pembroke Park, Florida. A notice of violation was sent by regular mail, July 16, 2024. An affidavit of noncompliance was sent August 1, 2024. An affidavit of noncompliance was also sent on February 2025. A notice of formal hearing with a copy of the notice of violation was sent by certified mail February 21, 2025, posted to the property March 6, 2025, and Town Hall March 7, 2025.
It was in my brain.
The violations are for lift station sewage overflowing to front drain, clean lift station drain, and repair lift station with a permit. Obtain plans for permit and inspections. As
Ms. McKinney, this is on case 9850. Also on is 7734-8288. 9580 is 2099 South Park Road, LLC. And the other ones are Pembroke Crown, LLC. That's we received the letter from Mr. Jeremy Shear, and we presented that to you. We're adding that to the file on these three cases. If we have a respondent, you can come up to the podium at this time.
And all three cases are up for a formal hearing?
9850, this was, when Mr. Shear and I spoke, was not brought up, just the other two for Pembroke Crown LLC. Though the first one is up for a finding of violation, the second two are for confirmation of fine.
Okay. Okay, let's do things in order.
And just to complete, my recommendation is 60 days, a per diem of $250, and a $100 admin fee for case 9850.
60 days and 250?
Yes.
Okay. And Attorney Sherman, yes, the attorney did send a letter, good morning, requesting what appears to be a continuance. I'm going to take it up individually. The first being for 9850, which is the first time up. And it looks like there's some work done without a permit.
No, they have to have a permit to repair the lift station according to our chief plumbing inspector.
Okay. Now, Attorney Sherman, you indicated you spoke to the attorney and 9850 was not part of the discussions. As far as your understanding, he was seeking a continuance at that time of the two other cases?
Yeah, the only ones that we spoke about were Pembroke Crown.
Okay.
But the reasoning, I was unaware that he represented until we got the email late last night.
Adding this.
Adding the third one, which was, again, the email came in roughly 7 o'clock last night.
Okay.
I don't know if the respondent has a copy. We presented the copy of the letter to.
Do you have a copy of
Kenny?
the?
Yes, ma'am.
Okay. Can you state your name for the record, please? And
Tony Raz,
say it again.
Tony Raz.
Hello, Mr. Raz.
Good morning.
Good morning. Are you the owner of the property?
Yes.
Okay, you can speak in the microphone. Well, the record is clear. You're here, so the testimony provides that, notice. What I want to dispose of initially is the request for continuance that your attorney made. Let's talk about 9850. May I have a copy of the letter? I don't have it on my screen. I did read it. The town did show it to me. Yes. I just want to. Okay, so based on what is being stated for 9850, your attorney, indicates that it's been cured and you just are trying to get an inspection.
This thing is a real mix-up. Iris is the manager of the property. She had contacted the office here in regards to this issue, and we thought we were gonna have to change a pump. We didn't. We sent a plumber, they cleaned it out, and that was the end of it. And afterwards, the plumbing inspector
Yeah, the chief plumbing inspector.
came and said, you need a permit. But what do we need a permit for? We didn't change the pump. This is a sewage, clean out that we did. We called the company, they came, they cleaned it out. It's a normal service. And the Broward County came, they gave us a clean bill of health within 3 days, right?
I'm not sure. I didn't see
Well,
it.
it was the 20, the
The
20.
Broward County?
Yeah, I sent it to you. We spoke
And
about it.
they cleaned it. I just
I
called the
thought it was just a
plumber.
cleaning. I thought it was just a cleaning receipt that you sent me.
And you said you didn't actually need it, but it was, have the Broward County
Okay.
clients say that we aren't.
Can you speak in the record and give your name?
Iris Wooters.
Okay, hello, Miss Iris.
Good morning. How you doing?
Good morning. Okay, so, and that was sent to Officer Ramirez when?
Last year of August. between-
Yes, August 1, 2024, an affidavit of non-compliance was sent, but she did send me that.
After receiving
This-
the affidavit of non-compliance?
Right, she sent it to me. The cleaning was done. However, our chief plumbing inspector says that for the repair, a permit is required.
There was no repair.
There was a repair.
No, it was a
On what?
cleanup.
I just got off the phone with the plumber.
Why is there new PVC pipe on it?
A PVC pipe? I don't know, but I asked him, did we change the pipe? He said no.
Okay, well,
And we're not going to debate
Yeah.
the technicality, because again, we're just discussing the inspection request. So we don't have an inspection date set yet.
Because there was nothing repaired. like-
Okay, but we're here and we're not going to argue semantics, repair, replace, new, old, clean, etc. The code requires a permit for that.
And actually, just for the record, I did call before and I was told twice I did not need a permit.
Twice by two different people.
Yes.
Who told you that?
Mr. Austin, when I asked you, when Broward came, I said, do I need a permit for this? You said no.
you,
Jeffrey said
Yeah.
no. And then somehow the plumbing inspector said yes.
you have to separate the two. This is not the first time it's been cited. It's been.
The same
Right,
offense?
for the same offense. It was cited prior, maybe there was some miscommunication, maybe initially you didn't need a permit to repair because we thought it was just a quick repair. But then since the overflowage kept continuing to happen, I had the chief plumbing inspector go check it out for the second time, and he was the one who said that the permit is required for a repair.
And it was just clogged. It wasn't, nothing repaired.
Okay. Okay. I'm not an inspector, but I do defer to the expert. So this is the first time up. And the document you sent to Jocelyn is your representation that it's been cured. So you basically need like an after-fact permit. Is that correct, Officer Ramirez?
What I can do, because if you look at the photos, there's obviously some sort of change on the lift station. There was PVC pipe, meaning somebody went out there and fixed something. I'm going as the direction that our chief plumbing gave us,
Right.
that a permit is required for the repair.
But
Not
after I
sure-
was told that,
Not sure specifically why the chief plumbing said that, but that after his inspection, that's what he told me. That's why I generated this violation, and on the violation noted that a permit is required. What we can do is have the chief plumbing re-inspect it. However, my concern is when we start having a lot of rain, this might come back and, overflow.
A lot of what, rain?
Rain.
Right.
Well, it was addressed, and so far, so good. And if there's a problem, we'll address it as soon as it becomes a problem.
But that's part of that's part of the issue, is that the testimony that's been given is that there have been other issues. This violation here isn't the first issue presented with regards to, right? And I understand. And so the inspector on this occasion says, okay, you're going to have to get a permit, because your testimony is that everything is good. We don't need a permit, right?
that I was told.
Based on what you say you were told. But the plumbing inspector, who is the expert in this field, the technical expert in this field, and if it's in compliance, Mr. Raz, right? If your representation is that, no, the work was done, everything is good, then there should be no issue with complying and
We have no
obtaining,
issue. Whatever we need to do, we do. but-
okay, obtaining a permit, because that's what I'm not clear on. He hasn't submitted an application for a permit.
No.
They call this a lift station. This is a sewer pump that drains water and cleans up the septic tank. And I don't know what the mistake is. And again, we came here this morning to ask for a deferment until the next hearing, so we can be here with our attorney that can handle all of this and discuss this with you further. And that's all we asked for. It's not like we're going anywhere. We just asked for a continuance until the next hearing, so we can straighten out everything we have to straighten out, including everything that we're looking at. And we're in process and the other.
Well, that's going to depend on a few things. My next question is, what is the time frame to obtain? He would have to apply for a permit. Is it going to require, if not, he's going to have to go to the permit counter. Will it require any drawings or plans or professionals to supplement the application?
Yes, typically plans are required.
Okay. So that's that. For this particular case, 9850, I'm not inclined to continue it, because by your testimony, you said the work is done. So obtaining a permit application, submitting a permit application with the required documents, and then just calling for inspections. That's what it sounds like, because there's no work in between.
Right.
Right? Ms. Iris,
Yes.
your testimony, Mr. Raz, is that the work is done. So apply for a permit, get it approved, and request an inspection.
Was done with permission to do the work. That's all I'm
Broward
saying.
County's got a whole list and came back and inspected it, and they gave us a clean bill of health. And after that fact, they sent a notation to Pembroke Park, and Pembroke Park, somehow, the chief plumbing inspector came, and I don't know what he wants us to
Have
pull a
you
permit.
spoken to the plumbing inspector?
No, I have not. I wasn't in the town at the time.
No,
But
don't say that.
we don't even know what he wants us to get. We'll find out. We can call him and find out, what do you want a permit for? The pump wasn't changed. If there was a broken pipe and they changed the pipe, at least I'd like to know that, and we'll address it. Now, I just have to bring up a point in regards to plans and architecturals and so on and so forth. My 35-year relationship with Jose Ramos, I don't know if you remember who he is the architect that was handling. He won't deal with us anymore because of all the issues that we have with the rest of the town. With the rest of we have like 17, 18 different addresses. He stepped out. He don't want to deal with the town of Pembroke Park anymore. We hired Victor Hayes, and he's a little bit better. He's getting along with the town. So we're moving. Now, in regards to the 2099, if we need to have him draw something and get a plumber, we'll do it, but I don't know what he wants. So I'm going to let the plumber speak to him. I don't want to get involved myself personally, because he'll tell him, this is what we win, this is what we'll give him.
Well, the town is offering 60 days, and because there's no work, and I'm saying that loosely based on your testimony that you've indicated the work has been done, I do want to put on the record that the experts and the professionals in this area, they very well could have a different opinion or a different direction when they actually inspect. I am not an inspector. This is based on your representation, and by your testimony, Mr. Raz, you did not do the work, and you're not a certified. Okay, none of us in here, this room is. So there we are. We know that we're not experts in this field. So the experts could completely, and I'm going to defer to the experts, negate everything I've said with regards to the work being done. I'm saying that based on your testimony and representation. Now, the town is offering 60 days. 60 days or $250 a day will start to accrue. Is there anything else?
I'm not understanding what you're saying.
Well,
You're saying that we're gonna have a fine from today going forward?
No, in 60 days.
After 60 days, it'll start.
No, we'll address it. We'll get the architect or whoever, the plumber,
The
the inspector, to contact him and see what he wants.
So for,
I really don't know what he wants.
as to the continuance request for case number 9850, I'm going to deny that continuance request.
What does that mean?
Well, at the beginning, I said I was going to take up the continuance request case by case.
I see.
This case is the first time up, and your testimony indicates, and the letter also that was submitted on your behalf indicates it's been cured. So what we're dealing with is permits having to be pulled and an inspection to be conducted, and then that permit is closed out. The town is offering 60 days to have that done.
Now, what if the inspector goes and sees that there was no permit needed? I mean, because he's the one that's got to go now and inspect it, right? And say what it is that was fixed,
Well,
changed.
but the first step is to submit a permit application.
But if there's no permit needed,
May I jump in,
Okay,
Ms. McKinney?
please do.
If that information comes up, we'll deal with it at that time.
Right.
so is that going to be within the I have to wait for the plumbing to go within 60
If that's the
days?
case, speak with Ms. Ramirez. She'll reach out to our office, and then we can review it at that time.
Because I
What
understand-
ifs are, again, we have the testimony here today. If the facts or something else comes to light and it changes the analysis, then we can review it at that time. Other than that, you're asking for an opinion on a what if, and
It's a
we can only deal with the facts. So if the facts change, then we'll be happy to address and review it at that time.
And what I'll throw in for good measure, you guys are here following this hearing, you should definitely go next door. So as to the continuance for the continuance request for case number 9850, I'm going to deny that continuance request for that case. And unless there's anything else from either side,
I don't understand the difference between continuing or not continuing. Again, I'm not an attorney, so I don't understand what the ramifications are if you do or you don't.
okay, so the mere fact that I've denied the continuous request for that case, the testimony by the officer at the beginning with regards to the existence of the violation, right? And your testimony is all the work has been done. But it was done, hold on.
Pipe,
Yes, I understand. I understand what you're saying, Mr. Ra- I understand. But one of your violations is work done without a permit.
We already answered that one.
Right, you offered your, yes, you did put forth your position.
We were told twice, not once, twice, by code enforcement that we did not need a permit to
And
do this
building.
repair. I can swear to that, she can swear to that, and, you know, you can talk to Jocelyn also and see if he remembers. And as soon as the county came, they told us what we needed to do. We addressed it, asked if we needed a permit, they said no, and that was the end of it. At this point, if we need to call the inspector, let him come and tell us what he wants.
And there's record testimony that the plumbing inspector, correct, Ms. Ramirez, furnished an email?
No, not in an email. He went to the property, inspected pump, and he said that a permit is required for the repair.
That was after the fact that we fixed it with permission to do it without the permit.
And we didn't change the pump.
And also let the record reflect that on the notice of violation, it is written that a permit is
That
required
was
for the
updated.
repair.
I have the original one, didn't say
The
that.
original one didn't have that.
No, the original did have that. It's on the record.
No, it says after the fact you put the plumbing, because how would you know the plumbing inspector?
Oh, you're talking about
The original.
the comment about the chief plumbing inspector? Yeah, but on the initial violation, it says lift station sewage overflowing to French drain, clean lift station drain, and repair lift station with a permit. That was under the direction of our chief plumbing inspector.
After the fact.
No,
it was after.
what Officer Ramirez is saying is that that language was on the notice. Am I correct, Officer
Yes,
Ramirez?
yes.
That was on the notice. And I understand sometimes we don't read everything or complete, or sometimes we
No, I
gloss
read it, that's
over
why I
it.
called
Can
to
I ask
ask.
a question? Again,
Yes.
rather than us going back and forth, we asked for a continuance on the three-case or a deferment to the next hearing so we can have our attorney actually handle this situation. I don't do this, and neither does she. Can you please grant us this deferral for the next commission meeting before you put,
This is code enforcement.
sorry?
This is code
Oh,
enforcement.
next code enforcement meeting, you know, when you have your, just. it
What's
makes
the
life-
town's
We're
pos-
not trying to hurt anybody. Don't
No, I
try to
understand.
hurt us, you know.
What's
We
the
wanna
town's
know what-
position with regards to,
The town's position is to give 60 days,
okay.
250 per diem, and $100 admin fee. I also want to mention that this case originated from our public works crew, who notified me of the spillage of sewage.
And this
So-
is sewage overflow?
Yes, and then the public works crew told me multiple times. It was not just one occurrence, it was multiple times. I'm glad they got it fixed. However, that's why I got our chief plumbing inspector involved, because it was happening multiple times. I just want to secure that this has been repaired correctly to avoid any mishaps in the future.
Okay.
And I believe 60 days is enough to verify all that.
I don't have a problem with the 60 days, you know, to verify. I have a problem with a continuance or not. I don't understand the difference. If you're gonna put a lien on my building.
This
that's
is,
different.
this is not for, Attorney Sherman.
If I may offer a solution, Ms. McKinney, when is your next hearing date that you will be here? Is it in 60 days? That's what I'm trying to find out.
Yes.
That's in
yes.
May.
Right?
I had to think, are we?
Well, there's making sure, because again, sometimes you might switch or vacations or anything else. So here, if I may suggest from what I'm hearing, again, just trying to listen to everything here for this particular case. The next hearing date is May, what's the next hearing date?
We have a date.
For 60 days, the May one.
It's the third one. 21st.
May 21st. Okay. So for 60 days, then, if you're inclined to enter the order today, right, make the compliance date May 20th, right? Put this on for hearing for May 21st. And then at that time, you're able to, counsel should be able to appear. You'll be the one hearing it, right? It won't be another magistrate. And then at that point, you could take under advisement if there's any other changes, or you could amend your prior order, and counsel will be able to address that at that time.
I think
Again,
that-
I'm trying to listen,
To balance the equities.
to balance again, this is your discretion.
Yeah.
I'm not trying to overstep my bounds
No,
here, but that's
no.
what I'm, at that time, if you, again, agree to, as far as listen to counsel to amend the prior order, because you'll still have authority to amend it at that time. But to balance the equities, what I'm hearing is that there is a possible health and safety wellness issue as presented by the town, which is why you're denying the continuance based on that expression and testimony for the town, to make the record clear as to, again, balancing the equities. So at that point, the respondent will be able to have the full time to remedy any information. If there's additional information that you discover, you can present it at that time with your attorney. Ms. McKinney will then, you'll be able to, at that time, if you choose, based on the evidence at that hearing, readdress the order and amend it But given the fact that from what's presented, that the health and safety issues that are presented as far as the drainage as we move into the rainy season would be the basis for your order. And I think that would balance what the town is asking and as well as the request. And I think that's expressing your intent, if I may be so bold.
Correctly bolded. Plain English. Because as the town attorney so poignantly expressed, this is a health and safety welfare, because I think we all agree that waste should not be in.
Absolutely not.
Okay.
You take care of it within 3 days.
And I'm also, yes,
Inspections and all.
and that's great, as you should have. And I'm also hearing that aspect. And because this appears applying for the permit, and as town attorney expressed, when you go to the counter, if you hear a new information, right, that changes the facts and testimony as they've been presented today on May 21st, we can take that up. But I do want to express on the record is that you have to still comply with the order, and that is going to the counter, applying for a permit, paying whatever the permit application fee is, providing all your documents, scheduling the inspections and such. Or otherwise, because ultimately, until the inspector goes out to actually examine this, and this is my opinion and understanding, debating it at the counter, since the record reflects the inspector has already gone out there, that's not going to resolve the issue. Someone's got to go to the field. Does that make sense?
Question.
Yes.
We're gonna go for a permit. How do you want us to request, to do what?
If I may, Ms. McKinney, as far as that information, that would have to be addressed to the building department, not for Ms. Ramirez.
I agree.
What you've done, if that is your order, then you've given the 60 days of compliance. The compliance date will be May 20th. That means on the 21st, this will be your notice that this case will be put back on that particular docket. So you will be back here on the 21st. The town will do the paperwork, but you're on notice now that that's when it's going to be. And at that day, that's the first day after the first day that fines would accrue is the 21st, and you'll be back before here with any additional information. So I would suggest that the respondent would need to get that direct information from, given there are also prior questions, directly from the building department, and they can at that time if it's applicable.
Correct. Do you understand? Is there anything else from either side? Okay,
We're just
perfect.
gonna find out from the plumbing inspector what he wants, and then we'll make that application according to those requests. Because it's, again, the difference between a pump and a lift station, to me, it's Turkish. I don't understand.
We're not the experts.
Me either.
Right.
So,
That includes you
looking
too.
at the violation, it's like talking about a lift station, and this is not a lift station, this is a sewer pump.
I understand your
right, we'll talk.
position with regards to
We'll talk to the
the
plumbing.
technicality, but that's not for this venue. If nothing else by either side, I'll give oral pronouncement based on the evidence and testimony presented. I do find there is substantial and competent evidence to support the town's position. The respondent is ordered to come into compliance within 60 days, May 20th, 2025, or face a daily fine of $250 per day. The respondent is also assessed $100 administrative cost for today's hearing. And the record, I think I already placed on the record, the continuance request as to case number 9850 is denied as to that case. We're not going to take up the other two cases.
Well, the other two cases are on the docket. Are you granting? So the next case
Is
would,
there an objection from the city to continue the other two cases which are on for confirmation of the fine?
I would like to, I'm sorry. I would like to hear the cases and you make the decision. Like you mentioned earlier, hear the cases first and then you can make a decision if you want to continue or not.
here,
I'm gonna switch orders of presentation because you're the moving party on the motion. So as to the hearing to confirm the fines, and
may I read the case into the record?
yes, please.
So the next one we'll do is 8.4, case 7734, Pembroke Crown LLC, 2565 South Park Lane, Pembroke Park, Florida, hearing to confirm fine for business tax receipt required, delinquent business tax receipt fees and penalties.
Officer Ramirez, I agree with you. Let her present the case. I'm not going to rule on it. And then your position. When I hand it over to you, Mr. Raz, I want you to explain to me, your attorney has written the basis of the continuance for the cases that are on for confirmation, which is case number 7734 and case number 8288.
The whole point of us asking for this deferral is for us not to actually stand here and do this. We are not lawyers.
Okay,
We're not capable of doing what needs to be done here in this case. Have I ever come in here without an attorney?
I've seen you before without an attorney.
No, you have not. I don't come into this room without an attorney.
Okay.
I didn't, and I saw you last time, and we did what we did. It's okay, it's fine, it's moved on.
Well,
But
then
now-
tell me in your words, why are you seeking to continue case number 7734 and case number 8288?
Oh,
Those two cases are on for confirmation of the fines, which fines have been accruing as to those two cases. You realize that, right?
Of course, and I'm here now because my attorney couldn't be here. We
Okay.
asked for this deferral so we can have this conversation and discuss the matters of this case and the details of the case, of the cases, when he's with me. I don't think it's right that we could continue to do this, and, we're not asking for 90 days, we're asking for the next meeting of your meeting. For us to come, first of all, as far as the 2565 and the 2517, both of them are already in process. We had removed tenants from these facilities. We went and got new architects to do all the drawings. We presented it. We already have a process number for 2517. We already have the architectural drawing.
2565.
2565, and we have that we just received, no, the 2517 is.
No.
I'm gonna, Mr. Raz, I'm gonna read into the record what the attorney indicates, and then I'm probably gonna have some questions.
Okay.
Okay. As to case number 7734, the attorney indicates the case is at 2565. He indicates that this property had a BTR every year until the year 2022, under the previous name AC Customs. And in 2022, one of the partners passed away.
Correct.
That's the partners of the actual
Okay.
tenant. Okay? This is what he indicates, which resulted in a new business or new entity being formed and applying for a BTR. Okay. But that was denied because a lack of safety plan, right? Pause here. Does the town have any objection?
Excuse me. Can you please sit down? Thank you. We're having a hearing.
If there's anything that's represented as to the request for the continuance, I would like for the town to edify on the record, if the town's record differ from what's stated, as to the BTR being denied for lack of a safety plan. The request also goes on to indicate there had been numerous attempts by that tenant to come into compliance. And last year, you, Mr. Raz, you took matters in your own hands. This is your attorney's words. And you hired appropriate professionals.
The new architectural.
Okay. Which include the architect, civil engineer, and to expedite the matter to obtain approval. Did you apply for a permit?
I just got the plans today.
From the, professional. Okay. And you're going to be applying
Yes.
for a permit. Okay.
And he did apply, he has an application for the BTR in since September.
But the life safety plan.
But when the fire inspector, after you do the BTR, they come and do an inspection, and they tell you what to correct before you can get the BTR, and that's what we're doing.
Okay. As to what's stated here that I've read in the record, what's the town's position or weigh-in or anything they'd like to add or supplement for?
This is all new information to me. Nobody has reached out to me to let me know what's going on with the property. However, when I did go ahead and re-inspected 2/21/2025, I did issue an affidavit of non-compliance because, let's see, Yeah, none of it has been corrected. There hasn't been a business tax receipt corrected, and there's still somebody operating in the unit.
Okay.
So, again, are you receiving the affidavit of non-compliance notices? Who does it go directly to, the attorney?
The last one that we received was sent to us by the tenant.
Okay,
So it wasn't sent to us, but, you know, we received it and we're taking the measures to take care of the problem. But, again, we lost our architect, so again, we lose all this time and,
But he did apply for the BTR. We're just,
because if you are not getting the response that you need from your tenants, you need to request an extension. So that way you have more time to correct, that way the fine doesn't accrue.
well,
But there's no communication, and we don't know what's going on with the tenant.
and, last week, we got the bill, it was $6,500 for the architectural work. We called them in, we told them, you know, you have to participate in this, you know, it's not our doing that created this, violation.
Of course, of course.
And you know what, they cry and they complain, but, you know, I told them, okay, you'll pay 20% or 30% of it, we'll pay the rest, just so we could move forward. And, it's in motion, it's going. We got the plans and you'll get it in the city and we'll continue to resolve these issues.
Madam Magistrate, and I'm just, okay, they had their attorney request for a continuance. There's a lot of puzzle pieces that haven't been discussed about. I guess we can give them the opportunity, you know, so you and I can have a conversation about what's going on and rectify, because, I mean, this particular case has been open since October 2022.
Well, we know.
Yeah.
We know it's been, first of all, after we had tried to do whatever we tried to do, it seems to be that the norm in every single one of the units that we open permits for, we comply, or we try to comply, and we're finished, or we call for inspection. Everybody passes us, the fire marshal walks in. Fire marshal walks in, even though there is, all the requirements are done, he'll come up with something new. So what happens is we step back again. We have to go, we have to change the plans, and we have to change the plans, and then we have to get the contractors to come in and redo a wall, a light, you know, it's just new things, and it's not right that this should happen to us. We work, you know, just for an example, 2099, we've been trying to get it resolved, and, you know, as far as BTRs, the application is being put in. We must have called the fire marshal, what, 3 times already? Every time he came, he found something new that wasn't on the order prior. Again, we reserve, we go backwards, and we call the architects again, and then contract again. And this has been the scenario on all the addresses. I don't know what he has for us, but he doesn't like us. So he comes in, and he'll give us a note, and he'll tell us, this is what I want, we do what he wants, and he'll come in a month and a half or 2 months later, and all of a sudden, there's a new wall, just like that 2099 staircase. It's been there for 50 years.
I understand.
So we're having a rough time with this whole situation, and we're trying to comply, and we're trying to do the best we can. At this point, all we ask is for a little bit more time so we can actually get our balance here and see, you know, like you're saying with the plumbing, we'll go and find out what he wants, we'll call him right away. It's not a problem.
I am inclined for case number 7734 to grant the continuance. The other thing I want to point out is this is the first time that the officer is hearing this, and I have seen you here before, Mr. Raz. Not to, you know, you're memorable, and
Good thing.
that is a good thing. So it is hearing that Officer Ramirez is hearing this for the first time. That is not a good thing.
I'm not sure what part she's hearing for the first
What I read,
part.
what I read, so for purpose of the record, what your attorney wrote, right, as serving as the reason for the continuance, that was not, you know, shared. So I would definitely urge you through Ms. Iris, stay in communication, because this case may not have even been on the hearing to begin with. Communication is so important. If there's nothing else on either side, I'll give oral pronouncement. Based on the testimony and evidence presented, Good cause has been shown for granting the continuance for case number 7734. This case will be continued to May 20th unless there's an objection from either side.
No.
May 20th, 2025. So that gives you a 60-day continuance on that case. Really quickly, on the last case, case number 8288, respondent's motion to continue this case. I'm going to read what's on this, what's stated here. It says that this relates to operating without a BTR, outdoor storage, electrical work done without a permit, and having a mezzanine without a permit. It's represented by the attorney from Attorney Shear that the permits are in progress and it's anticipated approval soon. So you've submitted a permit application?
Yeah, we already have a process number.
We have a process
But
number.
that's you wanna tell them?
What? This is a unit that had caught on fire in March of last year in the rear from the tenant's charger, battery charger.
Oh, wow.
So that's the unit
Phone?
that,
No, it was an American Electric, right? They were like a charging
there was a charger.
electric bikes or something. There was a fire.
It burnt that unit. Now, you know, whereby the smoke was more of a damage than the actual fire, but we got him out.
So, yeah, it's
We can't have
cleared
this
it.
type of
Activity.
and you know, we asked him to remove the sign off the wall. He didn't do it. We asked him to do multiple things, and he's just dragging and dragging. And again, when we have our hands tied, it's their place when they have a lease. We try to enforce as best as we can, but the place has been cleaned up. The mezzanine
It's
was
gone.
removed.
Yeah,
Okay.
there's no outside storage.
We had mezzanine approval from 20 years ago
Okay.
for that mezzanine. This fire marshal came and said, "No, take it down." It's a $20,000 piece. We took it down, and we have permits into whatever else needs to be done there. So we're in process. We have the process number, and it'll be resolved as well.
Is there an objection to continuance on this case? Okay.
No.
Objection. If there's nothing else, I'll go ahead and give or
I have a comment. So 6 days from today is May 18th. You stated previously for the
Oh.
order May 20th.
So-
just want to confirm.
oral pronouncement, May 20th. So
Okay,
that's
so
like
when I do
60,
the order for both cases, it'll be
May 20th. And whatever amount of days that amounts to.
Anything else?
Thank you so much.
No. Any other address?
Is there anything else you want to add on this case, Mr. Raz? Before I give oral pronouncement for case number 8288?
Before you leave, just a second, so I can say something.
Okay. Is what you want to say, is it related to this case?
I would like to set a meeting with Jocelyn
Oh, okay.
in regards to all our addresses, and we'll go through one by one, because this is, obviously, you see things fall through and it becomes multiple fines, and it's not like we're not here, we're not trying to do, but we sometimes we can't catch up.
I understand. I'll go ahead and give oral pronouncement on the continuance granting it, if there's nothing else to add. Based on the testimony and evidence presented, there is good cause shown to grant a continuance for case number 8288. The case is continued to May 20th, 2025.
Well, 21st. The hearing's the 21st. On the other
I'm
cases.
sorry.
Yeah.
This matter is,
We know it's the 21st,
yes,
the third Wednesday of May.
never a dull moment with Mr. Raz. I'm joking. So your continuance is granted.
Thank you.
The case is continued until May 21st. This is confirmation. And for case number 7734, that case is continued to May 21st, because that's on for hearing for confirmation of fines. Which brings me to another point as to both case number 7734 and 8288. Your fines are still accruing. I do want to put that on the record. The fines are still accruing, and they will continue to accrue until such time as the property is in compliance. Once in compliance, you can apply for abatement of fines. Okay?
Okay.
Well, you can send Mr. Ramirez an email. We'll also inform her that you made a request to meet with her.
Yeah, we'll give her all the addresses and we'll go from there.
Sure.
Thank you.
Thank you.
Thank you, Magistrate.
Thank you.
Yes.
You'll get it in now.
No, you can sign it.
No, for the other continuance.
Oh.
Might as well just send it all together.
Okay.
Yeah, those orders basically just continue the cases, but we're putting it on the docket.
Oh,
That's really what
because
it
you
is.
had them as confirmation.
Yes.
Yes.
That's the seal.
Oh, you know what? Give me a piece of paper. Do you have Adobe? Okay, you can just lift my signature.
Can you just let me? That's a lot.
Oh,
And then I'll email you.
yeah.
Just in case.
Mr. Ramirez, just so you know, Mr. Raz requested to set up a meeting with you to discuss all his properties and
Okay.
suggested he send an email. All right, Ms. McKinney, may we call the
Yes,
next
we
case?
may. Yes, yes.
All right, the
yes.
next one is 9789. Ms. Nancy Romero signed in. This is for Pembroke, case number 7.3, Pembroke Park Warehouse Holdings, 3121 Southwest 21st Street, Unit 675, for repairs and installations without a permit.
Okay.
Good morning. Thank you for your patience. We're going to start with the town first, and then you'll have an opportunity to respond.
Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9789, property owner Pembroke Park Warehouse Holdings, site address 3121 Southwest 21st Street, Pembroke Park, Florida, lot 675. A notice of violation was sent by regular mail, June 21, 2024. A notice of formal hearing with a copy of the notice of violation was sent by certified mail, February 21, 2025, posted to the property March 6, 2025, Town Hall, March 7, 2025. The violations are for demolition of plumbing, electrical done without permit. I believe there's a permit under process for that one. Installation of new window without a permit. As of February 20, there's no permit for that. Installation of new glass door without a window. Installation of new garage door without a permit. Those two items also, I don't have a permit for those. And then there was concrete and rocks debris on the property that has been corrected, been removed. So my recommendation is to give them 90 days to complete the rest of the permits. And a per diem of at $350, since this is a repeat violation.
You have the repeat case number?
Yes, give me a moment. It's 7888.
Does that conclude your testimony?
Yes.
Okay. Hello, good morning. Can you please state your name for the record and who you are in relation to the subject property, and if you're here, and whether you are here on behalf and authorized to speak by the owner?
Yes, good morning. My name is Nancy Romero. I'm the Senior General Manager for Pembroke Business Park, and yes, I have authority.
Okay.
I don't know if you may recall, I've been here probably every other hearing. Just to give you a little history of this situation is we had a tenant that was in there that was the cause of all these illegal construction, et cetera, et cetera. The tenant, ironically, is a general contractor. So he did all this build out without a permit. When it was first issued, I was in agreement with him to please come and do the right thing. Long story short, we had to evict him because he was not doing what he was supposed to. It dragged because we had to get an attorney for the eviction, et cetera, et cetera. All in the meantime, I did not have access to the unit to see what was going on. Finally, he moves out. We closed the case of 7888. And the fees were paid. I believe it was like $60,000. Not to bring out other cases, but we have been able to close over 40 cases between 2023 to 2025, close to $500,000 in fees, general contractors, architects, et cetera, et cetera. So once the tenant moved out, I had called Jocelyn and we did an inspection. To our surprise, tenant had removed all the electrical, everything. Light bulbs, light fixtures, he moved outlets, he removed everything, leaving an entire mess. I have no power in that unit. On top of that, he built 2 illegal restrooms. He capped it. Well, he didn't even cap it. He just left the pipes there. So all the build out, he yanked out. He did all the like I said, electrical, plumbing, the floor, the window, the glass, the roll-up door. To be honest with you, when we did the inspection, I thought it was only for the electrical and plumbing, which is the most crucial part, especially the electrical. So this is the reason why I pulled a permit, and it has been closed. I don't know if you saw my email yesterday.
Right, I replied to your email. That permit is just for the demolition?
Of electrical and plumbing.
Okay. Do you have permits for the window, the glass
Like
door?
I said, to be
That's
honest,
still in the,
I didn't know that also needed to be
Yes.
repaired. So with that being said, and then giving you a little bit more information, we are under right now, it's been on a Superfund, meaning that property is under contamination. So the EPA, the government, et cetera, has informed us that they will be doing demolition on the south side of that entire property. You're aware of that, right? So we're not able to rent this unit as is. And the owners at this time does not want to invest any money into this, thinking that at any time they're going to knock down the buildings. So my email to Jocelyn yesterday, and I don't know if you saw it, is that in regards to these items, which is the glass door, the window, and the garage door, if we can just put that on hold until it either gets knocked down, or if it doesn't get knocked down and we do rent it to somebody else, we will do these repairs and bring everything up to code.
Well, I have a question. What's the time frame or timeline for the demolition based on what the EPA has said?
I've been on the property for 15 years. I've been hearing this story since then. Last year, we came very, very close to it, that they were going to knock it down in September. We gave notice to the tenants, and then it's zero. Quiet. Radio, so now we don't even know if it's going to happen, if it's not going to happen. I have a feeling that probably not to bring politics into here, but
I was thinking, you read my mind, not to speak politics, but are there any workers federally to continue on this property?
Exactly. So we don't know. The ownership doesn't know. Like I said, it's been radio silent, so we don't know if it's going to happen, if it's not going to happen. We do have attorneys and specialists and consultants doing their part as far as finding out what's going to happen. But for now, the ownership is just putting everything on hold in case they do get demolished. So my request is, can we just put that on hold? I have complied with the plumbing and the electrical.
But that's all a part of this same case, is it not, Officer Ramirez?
yes.
It's all on the same detail. So when you say put on hold, what that really means in practical effect is we'll do items 1, 2, and 3, but we won't comply with 4, 5, 6 because it may be demolished. It's whether there's one item pending to be complied, if it's a list of 6 items in a case, it's still out of compliance and fines will continue to accrue. And in this case, it's a repeat violation, which statutorily under the law, the town can ask for a higher amount.
How can it be a complete,
Repeat?
a repeat when we didn't know the demolition that he had done until you and I expected it after he moved out?
It's a repeat violation because it's work done without permits. So if he did a tenant build out without a permit and then he added more stuff, it's a repeat violation. Attorney Sherman, Is it possible? I mean, I have a little bit of knowledge about the Superfund site and demolition of certain parcels. Could we possibly do a stipulated agreement?
It's something that we'd have to look into based on the limited facts, at least, presented here. Regarding that, it's just a matter of having compliance now, or again, if something's acceptable as far as just, even just removing what's there as far as the demolition. That would be something that we can have a discussion after the fact, or after this hearing, to see. I'm not sure a stipulated agreement would be appropriate, but given some of the facts, we can try and assist and find a resolution.
Because they will have to get a permit for the window, the glass door, and the garage door. And I believe you don't want to remove them, correct? You want to?
I mean, if the simple or the least expensive would be remove everything and just put our standard build out there, then, we'll comply in this form. But just to go back, the building department unfortunately has not been very, how can we say, lack of better words, very responsive as far as turning in applications, getting reviews, getting the comments, and getting applications. I have records here.
You mean your turnaround time?
The turnaround time. That alone, I submitted, I believe, because the thing is, I also have to wait for the architect. So that's probably 2 months. Once I get the plans and I turn them into the building department, it was done in October. I didn't get this until February. So this is November, December, January, 4 months to get a permit. Comments, any response at all. Emails, I literally come here every week. Mara can testify, she can see, I'm here every single week trying to get these done, closed, and go forward. So 90 days, I don't think is enough time. So I would need,
Enough time for what? For the permits?
for the permits.
Okay. 90 days is what we can give you, and you have to I must remind you that this is a repeat violation. So for a repeat violation, we can give 10 days if we want to. We don't have to give sufficient time. But we're giving 90 days, and you can come back and ask for an extension.
Okay. So I do need to make the corrections, in other words.
Given the circumstances.
Yeah, well, I think what I'm hearing is that it's been approximately 15 years since there's been an impending demolition of that section. So, because initially when you said demolition, my thoughts are, oh, this is impending, this is forthcoming. But 15 years, it's a long time. And it's not to rule out that it won't occur, but with what we have before us, it has not occurred. And the other thing that came top of mind is that notwithstanding the knowledge of the possibility or the impending demolition, if I heard you correctly, is that the units were rented out?
Yes. There was a tenant there. I think he was there since.
And this would be in the section of the building that's subject to being demolished?
Yes.
Okay, so that's another concern, because it invites the possibility that notwithstanding the, demolition is coming, that the property could be rented out without the town's knowledge, because for the past 15 years, it has been rented out with the knowledge at the federal level with the EPA that at some point they plan on demolishing it. And so based on, that,
May I say something?
yes.
In other circumstances, yes, it would be rentable. But because the tenant pulled out everything, just to rewire the electrical probably cost $40,000-$50,000 because it's a big unit.
Right, I understand, but
So why invest all this money going forward if we know it's going to be demolished? So
Right.
currently, it's not leasable. We're using it honestly just to keep trash because people like to dump at my property, which she knows, and that's where we're keeping it until we get a dumpster out there for the trash. So like I said to her, in good faith, I will let her know, or the building department, once we do rent it, if we see it's not gonna be demoed, the building, it's gonna take another 15
But
years.
how long is that going to take? And I don't know that the town is necessarily willing to put this case on hold, and I'm not inclined to either, just based on the testimony that it has been rented out. And because a tenant could elect to rent it out and bear the cost of putting the electrical and bearing that cost. That possibility exists.
When that does occur, they would have to pull permits.
If I may, Ms. McKinney, as the owner of the property, they're, as you know, responsible for the property.
Right.
And at this time, there are current existing structures on the property that require permits. How they choose to comply is up to them.
Right.
As far as the windows, the door, as long as they exist, it needs to be permitted. Understanding that if they choose to demolish the property, then once the property is demolished, then that would also cure the violation. So how they cure it and when they cure it is up to them on how they do that. As far as it currently exists, it needs to be permitted because we could have a storm in, let's say, a few months. And then at that point, that's where the inspections for the doors and windows. As far as the interior, if they want to gut it out and again, demolish it, bring it to a square box, that's going to be up to them on how they choose to comply. But as long as the conditions currently exist, that's the town's position as far as this case is concerned, that it would need to move forward.
So the town objects to partial compliance.
Okay.
As you requested. Is there anything else from either side?
So currently, there's no penalties issued, right?
You have 90 days.
Okay.
Am I correct?
Yes.
And then
90
in those 90 days, if I haven't complied due to the lack of,
Right. If you haven't completed the permits and you need time, then you can request time.
okay.
I'll give oral pronouncement based on the evidence, thank you, and testimony presented. There is substantial and competent evidence to support the town's position that a violation exists. Respondent is ordered to come into compliance within 90 days or face a daily fine of $350 per day. For the record, this is a repeat violation, repeat case number 7888. Failure to come into compliance within 90 days will result in the daily fine of $350 starting to accrue and continuing to accrue each day until compliance. Respondent is also assessed $100 administrative cost for today's hearing.
Thank you.
Good luck to you. Do we have the repeat violation? Okay.
I had it corrected, so I know it's.
Thank you. We can call the next case when you're ready.
Next case on section 7.12. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 1396. Property owner Pembroke Road Center LLC, site address 3948F Pembroke Road. Notice violation was sent by regular mail, November 27, 2024. Notice of formal hearing with a copy of the notice violation was sent by certified mail, February 21, 2025, posted to the property March 6, 2025, posted to Town Hall March 7, 2025. The violations are 7 illuminated signs on the window area. Only 1 illuminated, non-animated, non-flashing sign is allowed. This has not been corrected. As of, let me see what day it was. As of February 20, 2025. Permit number 2211704, smoke and glass for exit and showcase lights. The permit is expired. Permit 2211725-0, Pembroke Road Center for channel letter sign. That permit is expired. And item number 4, smoke and glass operating without a business tax receipt. All these items have not been corrected as of February 2025. It is the town's recommendation to give 60 days with $350 per diem and $100 admin fee. This is a repeated case referencing the case 9700.
Good morning. Can you please state your name for the record and who you are in relation to the subject property?
My name is Jared Harper, and I'm the property manager.
And you are here with the owner's permission and are authorized to speak on his or her behalf?
Yes.
Okay. So it looks like this is a repeat violation, repeat case number 9700. And the town is offering 60 days to come into compliance or face a daily fine of $350 per day and $100 administrative cost. What's your position?
I was supposed to meet here with the tenant. The tenant didn't show up. I had them in the office on March 10th after the owners sent me everything. They live in Brazil, so they sent me everything via email. And I met with him in the office, and I actually signed and notarized a business tax receipt for him. Because it said that it needed.
You mean application?
Application, yes.
Okay.
Application for him, because it said that it needed the property owner or representative information on it.
Right.
And he did state that he was going to meet me here this morning, so then we can go over all the other violations. I'm not sure what's going on with the expired permits or, the permit applications for the building for that particular space right now. So I would like to get those permit numbers if possible so I can look into it and then call the tenant once I leave here just to see exactly what's going on. In regards to the signs, I did let them know once I found out. I actually spoke with Ms. Ramirez maybe February sometime when I'm a new property manager for this plaza. I started in December, and I went online to actually see all the open violations for the property. And I called her and I spoke just briefly about a couple of them that were open. So I was trying to get with all the tenants for even all the other violations that we have, just to make sure that they all get complied to, so the owner doesn't have to have any fines. So I know for the business tax, I signed the application for him, so that should be coming into compliance soon. So hopefully 60 days will be enough for that. For the signs and advertising, I did tell him that he only had 2 signs. Is that correct? That only 2 illuminating signs?
One.
Only 1? Okay, I did tell him 2. I'll tell him that it's only 1. He said that he would come into compliance for that.
And can you please let him know he has to completely remove them? It's not just turning it off.
Has to be completely removed?
Yes.
Okay. I'll have him completely remove it. But for the permits, I would have to look into more information for those.
Okay. It's really important that you communicate to your the property owner that this is a repeat violation. So the fines, the daily fines, if it's not in compliance, will be $350 a day. And so it cannot be overstated, the need for the owner to bring this into compliance. While I understand the tenant is the one that is the source of the violations, however, the owner is the one that is responsible for the violations.
Yes, that I do understand.
Okay, perfect. Is there anything else from either side?
You said the other violation was 9700.
Right.
Yes.
It was violation 9700. Okay, I can go on the website and just pull that just so I can see what the violation before was. It was for the exact same.
Right. That particular case, it was for no business tax receipt and work without permit. So that's why it's a repeat violation. When it's the same ordinance occurring at the same property owner, it's considered a repeat violation.
Okay, so the 9700 was work without a permit, and then this violation is having the permit expired for
It was work without permit and no business tax
no
receipt.
business tax receipt.
Yeah.
Okay.
And we only give 1 fine per case. We don't give per ordinance.
Okay.
Anything else, Mr. Jarrett?
No, I'll speak with the tenant and I'll give Ms. Ramirez a call when I can.
I would also state to you, so that you can communicate to the owner of the property, is that whether or not the tenant takes action, the owner is still responsible for compliance.
Yes.
Because it's their property. I'll give oral pronouncement based on the
I do
evidence.
have one more thing. Can I have those actual permit numbers? That way I can write them down. That way I can look into those as well.
Officer Ramirez, she can provide that to you. That's not a
Jean,
problem.
can you show him the case overview so he can screenshot it? First page?
The permit
First
numbers.
page, first page.
The permit numbers are on there.
Yeah. No. Well, yeah, go all the way to the first page,
Yes, sir.
or it should be there too.
Yeah, that's it.
You can screenshot it right here. If you want to take a picture, you have your cell phone. Or do you have a copy of that already?
I don't have a copy of this. Mine looks different. It just shows the case for this morning, and it doesn't have permit numbers on it.
Okay, while he's taking a picture, I'll go ahead and give oral pronouncement. Based on the evidence and testimony presented, I do find there is substantial and competent evidence to support the town's position that this is a repeat violation. Repeat case number 9700. The respondent is ordered to come into compliance within 60 days or face a daily fine of $350 per day, which will continue to accrue until such time as the property is in compliance. The respondent is also assessed $100 administrative cost for today's hearing. Good luck to you.
Thank you.
Did he leave?
Did he leave?
Here you go.
Yeah, can we grab him? Make it easy and save a stamp.
We're supposed to hearing also about the permit fine?
Sir, if you could just, we're in the middle of hearings, if you can just sign in, and then we'll be able to address it in the correct order. Ms. McKinney, should we call the next case?
Yes, please.
7.7, case 9840. That's Sweeney's 7 LLC, 4200 West Hallandale Beach Boulevard, Pembroke Park. This is for repairs and installations and permanent without a permit.
Okay. Rossi.
Rossi's. Yes.
Okay. I'll present the case.
Yes, please.
Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 9840, property owner Sweeney's V2 LLC, site address 4200 West Hallandale Beach Boulevard, Pembroke Park, Florida. A notice of violation was sent by regular mail July 15, 2024. A notice of formal hearing with a copy of the notice of violation was sent by certified mail February 21, 2025, posted to the property March 6, 2025, posted to Town Hall March 7, 2025. The violations are for seal coating and stripe parking lot without a permit. Item number 2, installed AC unit without a permit. These 2 items have not been corrected. However, for the installation of the AC unit, this is eligible for an amnesty program that the town has for business owners who acquire a property and installations were done without a permit. So that's for item number 2. However, for item number 1, that is not eligible for amnesty program. Therefore, it's the town's recommendation to give 90 days, $250 per diem, and $100 admin fee.
Hello, Mr.
Hello.
Jared, can you state your name for the record and who you are in relation to the subject property?
David Rossi.
I'm sorry, Rossi. Mr. Jared is to my right. The other gentleman. Mr. Rossi, are you the owner of the property?
I'm running it. My daughter's the owner.
Are you here with her authorization and
Yes,
permission?
yes.
Okay. So the town has cited for violations on the property. They're offering you 90 days to come into compliance.
Yes. That's fine. I got the permit for the asphalt. I paid the permit.
Okay,
I have the card.
okay.
I'm just
And it-
waiting for Anthony, striping, arrow striping.
Okay.
They pulled the permit. They paid it. Heather paid it.
And they completed the inspections?
No, they just gotta come and paint it. They gotta come and paint
Oh, okay.
the
All right.
striping.
So you have to complete the permit to be in full compliance?
Oh, okay.
Okay.
Okay, no problem.
So you have 90 days to do all of that. That
Yes.
means the inspector has to inspect, close out the permit. You have to notify the officer.
Awesome.
Okay, I'll give oral pronouncement. Based on the testimony and evidence presented, I do find there is substantial and competent evidence to support the town's position that a violation exists. The respondent is ordered to come into compliance within 90 days or face a daily fine of $250 per day, which will continue to accrue each day that the property is not in compliance. The respondent is assessed $100 administrative costs for today's hearing. Good luck to you.
Okay, and the AC,
Mm-hmm.
I got Muscare.
Okay.
They did an inspection of the thing,
Okay.
and I submitted the, can I show you this?
Yes.
This is what I got yesterday, sorry about that. This is the inspection that it's all in working standard.
Mhm.
There's a working order.
Okay.
We can call the next case. when-
Sure. All right, well, if you can just have a conversation off the record regarding that, we'll call the next case.
You want to have the conversation on the record, right?
Yes.
Yeah,
Okay,
Yes.
yeah.
I have
Okay,
Sorry.
so,
Announcement.
right,
oh,
'Cause
you
this-
already made the oral
I
pronouncement?
did.
Okay,
Yes, so
All
this
right.
was,
so just submit this to the building department.
I did yesterday.
Oh, okay,
And because this property, we bought it about 7 months ago, 8 months ago. And this was something that was done from the old owner.
yeah,
So
okay.
I'm just
Here's your
getting it
copy.
up to code where it
No,
should be.
I understand. In these hearings, it doesn't say you owner, you did it. It says owner, you're responsible. It's
Yes,
your
yes,
property. Okay.
yes. But we have good communication with the city, so
Yes,
we'll
make
take care of it.
Yes, make sure you stay in communication with the officer. That's so
Yes.
important.
Absolutely.
Okay.
Thank you.
Good luck to you.
next case is 7.9, case 9851, YBY Investments LLC, 3911 Southwest 52nd Avenue, Building 3, Unit 3, in Pembroke Park, Florida. This is a hearing for a formal violation for repairs and installations without a permit.
What item? Which item?
7.9.
7.9,
Okay.
9851. Is there
Chief.
Isaac Hayden?
Yes, sir.
Hayden.
Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9851, property owner YBY Investments LLC, site address 3911 Southwest 52nd Avenue, Pembroke Park, Florida, Building 3, Unit 3. Notice violation was sent by regular mail, July 17, 2024. Notice of formal hearing with a copy of the notice violation was sent by certified mail, February 21, 2025, posted to the property March 6, 2025, posted Town Hall, March 7, 2025. Violation is for installation of a wooden fence without a permit. As of February 20, 2025, it's not in compliance. It is the town's recommendation to give 60 days, if not $100 per diem fee and $100 admin fee.
Hello.
How are you?
Thank you for your patience. If you could state your name for the record
I'm
and
even
who,
surprised of myself today.
and who you are
My name is
in relation to the
Yitzhak
subject property.
My name is Yitzhak Hayun. I'm the property manager.
Are you here with the owner's permission and
Full
authorization to speak?
Definitely, ma'am.
Okay.
I'm sorry, can I make a comment? Could you please spell out your first name?
I as in India. I knew it's gonna come. I as in India. T as a Tom. Z as a zebra. H as in Henry. A as an apple. K as a kilo.
That's it.
Last name. H as in Henry. A as an apple. Y as a yellow. O as an Oscar. N as a Nancy.
Thank you.
Thank you. So first of all, it's not installing new fence. It's repairing a fence. There was fence before. What we did, because it was rotten, we changed the wooden fence, the portions. Now, when I think I spoke to you or someone in the city, in the town, due to the fact it was exceeding the amount that allowed to be considered as a repair, we had to pull a permit.
Correct.
We pulled a permit, and due to the fact that it takes, like everybody else suffers from here, takes a long time, too long,
to even getting a permit submitted. Even the contractor that I used is, and you can put it on the record, it's a shame. The contractor was even depressed from this. So, but finally, yesterday after I had to call because the town using outsourcing for reviews, I had to call, I spoke to Jeffrey, which was actually very, very helpful. He saw the frustration, so he helped us. And on the same token, I had to call myself to the reviewer, which her number started with 561. I forgot the lady's name. And I didn't understand why she even, I don't think even Jeffrey understand why she actually denied the review at the beginning. It was a joke, but finally we have it. We have the permit. The work was done. All we need to call for final.
Oh, okay. Well, congratulations on, moving things along. The town is offering 60 days.
I'm good with this. We're gonna close it by hopefully, it all depends again on building department to come and do an inspection. So it's in their court. We're gonna call for final, I guess, the second I get the card today. It was approved yesterday, the final revision. So I need to talk to Jeffrey, get the card and do the final inspection.
Okay.
And I would recommend that maybe stopping by the building counter.
Is it in the building here?
Yes, the building department's next door.
First time here.
Have you
so-
been in the lobby?
Yes,
Okay, so in the lobby, you'll see the building department,
perfect.
right next to the police department.
And make sure you document your efforts and diligence. Okay?
Just to let you know, I believe in this and I agree with you. And everything that I say to my assistants, send an email as well. I have everything documented, even the frustration I have with the city. After every call, I send them an email. So believe me, I learned my lesson a long time ago. And I really hope, because this is a great area. And they're doing their job. I'm not going to come, and I'm not one of those people. But if they're doing their job, they need to have backup. If someone come and apply for a permit, and 4 months you are unable to provide a permit, it's ridiculous. It's hurting you. You guys want the money. Not only the money, you want the safety of the people.
Compliance.
Compliance, for me, it's safety more than compliance.
Well,
because
safety.
we care about the people to be safe.
Correct.
And if all this will be easier, you'll make more money and people will be safer. So, but I do appreciate you granting me the 60 days that we're going to finish with this. And that's it.
I'll go ahead and
Anything
give
else?
oral pronouncement if nothing from either side. Based on the testimony and evidence presented, I do find there is substantial and competent evidence to support the town's position that a violation exists on the subject property. Respondent is ordered to come into compliance within 60 days. Failure to come into compliance will result in a $100 per day for each day the property is not in compliance, per diem fine. The respondent is also assessed $100 administrative cost for today's hearing. Good luck to you, Mr. Hayden.
Thank you very much, man.
You're
Thank you very
welcome.
much, too.
Next is case number 8.7, case number 8065, or let me see, 1 second. This is your hearing to confirm fine 8305, excuse me. 8.7 under docket. That's Miss Eartha Wingham, 3911 Southwest 52nd Ave, numbers 1 through 3, Pembroke Park, Florida, for repairs and installations, demolition, needed correction, permit applications.
Okay, that, in the beginning of the hearing, we mentioned that we are removing the confirmation of fine, and they requested an extension, so we added for an extension of time, and it's on item 10.1.
Could you put that, Attorney Sherman, it's 10.1. And
Oh,
that was one of the modifications.
okay.
Yes,
I know that Miss Wingham is here.
yes,
That's why I called it.
okay. Yeah, that's the one.
Okay, so it was moved to understood.
Yes.
Okay. The way it was signed in, forgive me. So 10.1, it's now being moved for the motion to extend time. Same case, same information.
Yes. So, Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8305, property owner Eartha Wingham, site address 3911 Southwest 52nd Avenue, Pembroke Park, Florida, Unit 1-3. A notice of hearing to extend time was requested March 11, 2025. It is the town's recommendation to give 60 days, if not the per diem of $100 and $100 admin fee.
This was originally on for final hearing.
Confirmation of fine, yes.
Right.
Oh,
And then,
okay.
and then it was moved to on this time. So it's still on both items on the docket. So it's
Right.
number 8.7 and 10.1.
Okay.
But it was removed from confirmation of fine to only 10.1
Okay.
being heard.
I do have a question. Since fines are already accruing, so they will continue to accrue.
No, it will reset the clock because we'll enter an amended final order.
Okay, that's the part I didn't get. Hello.
Hi,
And
good
thank you for your
morning.
patience. Good morning, or yes, good morning. Thank you for your patience. Kindly state your name for the record and who you are in relation to the subject property.
I'm Eartha Wiggum, and my address is 3911 Southwest 52nd Avenue. I'm the owner.
Okay. So your case was originally on to confirm the fine. The town's recommendation is to amend the final order and kind of give you a reset, a new date to come into compliance, which is 60 days. And in that time, you have to come into compliance, and if that requires permits being closed out, but if not, fines will then begin to accrue within 60 days. I'm sorry, after 60 days, on the 61st day, fines will start to accrue, of $100 a day.
Understood. Thank you, Ms. Ramirez, and thank you, Your Honor. Had I known that I could have called for the final inspection, I would have. But with my contractor, Mr. Jean, he told me he would take care of everything, also pull a permit for the fence. So when Ms. Ramirez left her love letter on my door, I immediately called her, and she explained everything to me, and I called him. And he did not follow through. And I said, what is going on? Oh, I forgot, I got busy, and it's like you're getting me deeper in trouble. So he promised me that he would pull the permit for the fence. And I'm going to give him a call once all of this is said and done, so that way he can come and pull the permit for the fence, because the fence was put up. And he said he would take care of everything. And also, I didn't know that he would have to sign off on the permit, which he never did. He never set up anything. So this is why, I'm where I am today.
No, I understand. But just so you understand, that the town, I'm sure based on the circumstances you brought to their attention and wanting to assist you in getting in compliance, is extending the time by amending the final order. Am I correct,
Yes.
Officer Ramirez? And so by virtue of that, be entered today, you will have 60 days to complete everything. And so that being said, you are going to have to really get on top of this and stay on top, which I'm sure you already are, with your contractor, because after 60 days, fines will start anew. So you're getting a complete reset.
How long does it take to get a permit for the fence? I mean, the time period.
I don't know the answer to
You
that
don't?
question.
Okay.
But of course, once you're done here, you are certainly urged to go to the building counter and to speak to someone
Okay.
there to be able to assist you.
It should be 30 days. 30 days for the permit
To be issued?
to be issued.
If there's no comments.
Right, and the contractor also has to respond in a timely manner.
Okay, he will.
I'll go ahead and give oral pronouncement. Based on the testimony and evidence presented, there is substantial and competent evidence to grant an extension of time, amending the final order to reflect that the respondent is ordered to come into compliance within 60 days or face a per diem fine of $100 per day, which shall continue to accrue until such time as the property is in compliance. The respondent is also assessed $100 for the administrative cost of today's hearing. Good luck to you.
Thank you. Thank you, Ms. Ramirez.
You're welcome.
Next case is on for a reduction of fine, case number 9.4. On the docket, case 9443. It's 5525 Southwest 41st Street, Pembroke LLC.
Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9443. Property owner 5525 Southwest 41st Street, Pembroke Park LLC. Site address 5525 Southwest 41st Street, Pembroke Park, Florida. A notice of hearing to abate fine was requested via email March 12, 2025. It is the town's motion to reduce the fine of $20,350 by 85%. That total amount is $3,138, and that includes the admin fee.
3138 even?
Yes.
Okay. Good morning. Thank you so much for your patience. If you could please state your name for the record and who you are in relation to the subject property.
Yes, good morning. My name is Randall Perez, and I'm the property manager. And yes, I was sent here acting on behalf of the ownership.
Thank you, Mr. Perez. So the town is offering to abate your fine from $20,350 to $3,138.
Okay. Okay.
Okay. If nothing else by either side, based on the testimony and evidence presented, there is substantial competent evidence to approve the request for abatement. The property is in compliance. The fines are abated or mitigated from $20,350 to $3,138. The respondent must pay the mitigated amount within 30 days, or the original fine amount will resume. Do you need more time?
No, I believe 30 days should be fine.
Okay, if anything arises, please be in contact, because if it's not paid within that time period, the original amount will resume.
Yes.
Okay,
Thank you very much.
you're welcome. Good luck to you.
Thank you.
Have a
Thank
nice
you again
day.
for your patience.
The,
Okay.
Yes.
Thought you were going. Yeah. And this is 38. It's okay.
and Ms. McKinney, I can call the next case when you're ready.
Yes, 1 second. Mr. Perez? Oh, yes. I just want to restate on the record that it's $3,138. You will see some corrections that I've made, but verbally, and I've written it down, so you may wonder, what's all this? It's $3,138. Thank you. We can call the next case.
Thank you. The next case is case 8.1 on the docket, case 6006 LIVMA LLC, 2050 Southwest 30th Ave. This is a hearing to confirm fine for prohibited signs and looks like permits required. The gentleman did come in.
We have to swear him in.
We have to swear him in.
When you're ready, can you raise your right hand? Do you swear and affirm the testimony you'll provide will be the truth and nothing but the truth?
I do.
Okay.
Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 6006, property owner Livma LLC, site address 2050 Southwest 30th Avenue, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail February 21, 2025, posted to the property March 6, 2025, posted to Town Hall March 7, 2025. It is the town's motion to confirm the fine of $188,600.
$188,000?
And $600.
Okay. Can you please state your name for the record and who you are in relation to the subject property? And
Yes,
if you're
my
not the
name-
owner, Can you please indicate whether you have the owner's permission to be
I
here?
do have the owner's permission.
And your name for the record?
Vadim Rogachevsky,
Rogochevsky? Okay, thank you, Mr. Vadim.
of course.
So the matter is on for confirming of the fines. What was the mitigated or abatement amount?
No, this is not being abated.
Oh, I'm sorry.
This is a confirmation fine, and the fine is still accruing
Low
until
blood sugar.
until the violation is corrected.
Did
So
you
the
mention-
property's not in compliance,
Yeah,
and we're here to confirm $188,600.
based on what? I'm sorry?
Based on the violations not being complied with.
So the violation, from what I understand, occurred based on our sign that we basically did not install. It was there. We've been there for 12 years plus. It was installed and the person that was doing the electrical work took out the permit, but apparently did not order the reinspection at the time of the work finished.
Okay,
So we've hired a company that's now reapplying for that same permit. It's called Shark Signs. They are receiving the permit.
okay. I understand.
So that $188,000 does not sound like anything that's any reasonable person would assume. So if that's something that we have to deal with, we obviously have to hire the attorney and deal with it.
Okay. And you're certainly free to hire an attorney. This hearing today is to confirm the fine, which means that it's really to determine, one, is the property in compliance? If it is, ascertaining the date of compliance. And if it's not, to confirm the fine. How someone gets to a hearing to confirm the fine is because a final order was issued prior and that was not complied with. And so
When was the final order issued?
There was a final order issued October 19, 2022. Then an extension was requested. So there was an amended final order January 25th, 2023.
So when someone doesn't come into compliance, fines start to accrue and they run until compliance is
So
achieved.
when did it start to accrue exactly?
How long have you been working as the property manager or point
I am
person?
not a property manager. I'm a sales manager. We had different people that were working with that particular person. I only became aware of it in February of this year.
Okay, so
Jane, the case is 6006.
Yeah, right here.
No,
okay,
that's 6620.
so by your own testimony,
No, on the screen,
And
you
the
have
record
6620.
the owner, through whoever his agents are, was aware of this case, and aware of exactly what I'm stating to you is that without
I became
compliance.
aware of it in February of this year.
Okay, that's not what the record reflects, but we're not here to dispute that. So if there's nothing else on either side, I'll go ahead and give oral pronouncement for this confirmation of fines.
Did you ask for the compliance date?
I did not.
Oh, did you?
Yeah.
The compliance date was February 25th, 2023.
Okay.
So in the 2 years, we've accumulated the fine of $188,000 for not having the permit on the sign that was originally on the building, did not do any changes to it. We just, nothing. We did nothing. We replaced the sign, just the material that goes over it. So
Well, we're here to
based upon
confirm-
that, is-
And I appreciate what you're stating on behalf of the owner. Again, this is a hearing to confirm the fine.
What exactly is the next step as far as we're concerned?
Compliance.
Compliance meaning what? That we need to
Close the permit.
close the permit?
Yeah.
Okay. What about the fine? Because we also. hear
Well,
this-
once a property is in compliance, you weren't here earlier in the hearing, but once the property is in compliance, the fines stop accruing on the date that it comes into compliance. The property owner is free to apply for abatement of the fines with the town.
Okay, I got you.
Yes.
All right.
Okay, I'll give oral pronouncement. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for, I'm sorry, strike that. My mind. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. To date, the property remains out of compliance. The respondent is still ordered to comply and correct the violations. Failure to correct the violations will result in the daily fines continuing to accrue until such time as the property is in compliance. The respondent is assessed $100 administrative costs for today's hearing.
Understood.
So, Mr. Vadim, please share with the owner, because the owner is responsible for the violation. That's just the way the law in this area is. And so, please apprise him that the fines are still accruing.
Understood.
Okay? Thank you. Good luck to you.
Thank you.
Ms. McKinney, that includes,
You're gonna receive a copy of the order.
that concludes everyone in the room and everyone who has signed up for these hearings.
You have to announce it on your mic,
What do you, wait,
that you, to wait for you to give them a copy.
Oh, he did not look like he wanted a copy.
No, we
I don't
want
think
to
he
put
knew.
on the record that we made it available to him.
Okay.
That he walked out. We said that we would give it to him. We'll still mail it to him as required.
Correct.
But on the other hand, is as we do for all our cases, handing out the orders in person.
Okay.
So it's I would kindly request a few minutes,
I would really-
a break, please.
I stopped drinking coffee.
Yes.
I don't know if that's a good thing.
So we're going into intermission?
Intermission.
Fun time. Okay, ready when everyone else is.
Let's get started. Don't wait for me. I gotta take care of it. Let's get started.
Brian has done a good job calling the cases.
It's too quiet.
God bless you. Bless you. Back on the record. Back on the record. Time is 12:14.
Okay, we will go in the order of the agenda. So item 7.1. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 6326, property owner Shady Oaks, MHP LLC, site address 3250 South 31 Way, Pembroke Park, Florida. A notice of violation was sent by regular mail September 28, 2021. And I'd like to state for the record that this case was former officers Teresa Malcolm. And so I reassigned it. And so I'm going to present it. A notice of formal hearing with a copy of the notice violation was sent by certified mail February 12, 2025, posted to the property March 6, 2025, and Town Hall March 7, 2025. The violations are for new wooden stairs installed without a permit, overgrown the windows were covered with wood, as in to block the windows. They have removed that wood from the windows. They've taken care of the overgrown vegetation. They just need a permit for the wooden steps. So it is the town's recommendation to give them 90 days to do so, if not a per diem of $250 and a $100 admin fee.
Is anyone here on case number 6326, property located 3250 South 31st Way, Unit 13, 14, 15, 16? Seeing and hearing no one come forward, based on the testimony and evidence presented, I do find there is substantial and competent evidence to support the town's position that a violation exists. The respondent is ordered to come into compliance within 90 days or face a $250 per diem fine, which will continue to accrue daily until the property is in compliance. The respondent is also assessed $100 administrative cost for today's hearing. Next case.
Next case is on agenda 7.4. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9791, property owner 3535 Southwest 52nd Avenue, LLC, site address 3535 Southwest 52nd Avenue, Pembroke Park, Florida. A notice of violation was sent by regular mail June 21, 2024. A notice of formal hearing with a copy of the notice of violation was sent by certified mail February 21, 2025, posted to the property March 6, 2025, posted to Town Hall March 7, 2025. The violations are for installation of multiple AC units without a permit, installation of canopy without a permit, and swell area in front of the property is bare and requires new sod. They did put new sod in the swell area, and they still require permits for the canopy and the multiple AC units. So it is the town's recommendation to give them 90 days, a $250 per diem, and a $100 admin fee.
And for the record, we're on case number 6663? No. 9791?
Yes.
Yes.
Okay. Case number 9791, property located at 3535 Southwest 52nd Avenue. Is anyone here on this case? Seeing or hearing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support violation exists on the subject property. The respondent is ordered to come into compliance. Was that 90 days?
Yes.
within 90 days or face a per diem fine of $250 per day, which shall continue to accrue until such time as the property is in compliance. The respondent is assessed $100 administrative costs for today's hearing. Next case.
Next case on section 7.6. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9803. Property owner South Park Lane LLC. Site address 2589 South Park Lane, Pembroke Park, Florida. A notice of violation was sent by regular mail, June 26, 2024. A notice of formal hearing with a copy of the notice of violation was sent by certified mail, February 21, 2025, posted to the property March 6, 2025, and Town Hall March 7, 2025. The violations are for operating without a business tax receipt or certificate of use that has not been corrected, doing construction work with permit, but the nearby drains did not have proper mesh covers for sediment control. So therefore, they will have to show receipts of cleanups and make sure that they're taking preventative measures for sediment control. That has not been corrected. So it's the town's recommendation to give them 60 days to correct all violations, if not a per diem of $250 and $100 admin fee.
Case number 9803, property located at 2589 South Park Lane. Is anyone here on this case? Seeing or hearing no one come forward. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that there is a violation existing on the subject property. The respondent is ordered to come into compliance within 60 days or face a $250 per diem daily fine, which shall continue to accrue until such time as the property is in compliance. The respondent is also assessed $100 in administrative costs for today's hearing. Next case.
Next case on section 7.10. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9852. Property owner Julian Beck. Site address 3911 Southwest 52nd Avenue, Pembroke Park, Florida. Building 3, Unit 4. A notice of violation was sent by regular mail, July 17, 2024. A notice of formal hearing with a copy of the notice of violation was sent by certified mail, February 21, 2025, posted to the property March 6, 2025, posted to Town Hall March 7, 2025. The violations are for installation of wooden fence without a building permit. Item number 2, roof reflat work was done without the completion of the permit. That permit has been completed, and the wooden permit is what remains. So it is the town's recommendation to give 60 days and $100 per diem with $100 admin fee.
Case number 9852, property located at 3911 Southwest 52nd Avenue, Building 3, Unit 4. Is anyone here on this case? Seeing or hearing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 60 days or face a per diem fine of $100 per day, which shall continue to accrue until such time as the property is in compliance. Respondent is also assessed $100 in administrative costs. For today's hearing, next case.
Next case is on section 7.13. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 10545, property owner BDRC Pembroke Park LP, site address 3301 West Hollandale Beach Boulevard, Pembroke Park, Florida. Notice of violation was sent by regular mail, January 22, 2025. A notice of formal hearing with a copy of the notice of violation was sent by certified mail, February 12, 2025, posted to the property March 6, 2025, posted to Town Hall March 7, 2025. The violations are for multiple snipe signs on the property. Item number 2, 2 sandwich signs on or A-frame sign on the property. Item number 3, banner sign in front of the property. Item number 4, spilling of trash onto the neighboring property. They have corrected item number 4 which is the cleanup of the trash. However, they still have all the signs out on the property, so it is the town's recommendation to give them 10 days to remove those signs. If not, a per diem of $250 and a $100 admin fee.
That was 10 days?
Yes.
250 and 100. Case number 105545, property located at 3301 West Hollandale Beach Boulevard. Is anyone here on this case? Seeing or hearing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 10 days. Failure to come into compliance within 10 days shall result in a per diem fine of $250 per day, which shall continue to accrue daily until such time as the property is in compliance. The respondent is also assessed $100 in administrative costs for today's hearing. Next case. Oh, okay.
Next case is item 8.2. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 6620, property owner Murray Family Associates LLP, site address 3192 West Hollandale Beach Boulevard. A notice of hearing to confirm fine was sent by certified mail February 21, 2025, posted to the property March 6, 2025, posted to Town Hall March 7, 2025. It is the town's motion to confirm the fine of $31,100, and it is still it continues to accrue until the violation has been corrected.
Case number 6620, property located at 3192 West Hollandale Beach Boulevard. Is anyone here on this case? Seeing or hearing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fine. To date, the property remains out of compliance. The fines are hereby confirmed. The respondent is still under an order to comply and correct the violation. Failure to correct the violation and come into compliance will result in the continued accrual of the per diem fine. Respondent is assessed $100 in administrative cost for today's hearing. Next case.
Next case on 8.5. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8279. Property owner Steve Lapointe, site address 148 Westlake Drive. A notice of hearing to confirm fine was sent by certified mail February 21, 2025, posted to the property March 6, 2025, in Town Hall March 7, 2025. This particular case is for installation of 7 impact windows without a permit. And I would like to request for this case to be continued because the owner is in Canada, and he did send me a couple emails. Okay. Apparently, there's been some miscommunication in the building department, so I would like to give him the opportunity to sort those things out, because he was under the impression that the permit was completed.
Okay.
So he said that he was going to come in on April and sort everything out. So if we can continue the case to the following hearing.
April or May's hearing?
It would be so May's hearing.
Okay. Case number 8279, property located at 3148 Westlake Drive. Anyone here on this case? Seeing no one or hearing no one come forward, it is the town's motion to continue the case without objection. There is good cause to grant the request. Case number 8279 is continued until, that would be May 21st is the next hearing that I'm here. May 21st, 2025. The property owner is still under an order to comply and to correct the violations. Until such time as compliance is achieved, the daily fine shall continue to accrue. Respondent is assessed $100 administrative cost for today's hearing. I think we're going to have to amend this order.
Oh, which one?
This is on case number 8279, not this one. Or do you have it?
for confirmation?
No,
Fine.
yeah, we're changing it to a continuance.
Continuance?
Yeah.
Until May 21st? Still under a continuing. Doesn't change the prior final order to continue, to comply. We can call the next case when you're ready.
Next case on section 8.8, Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8359. Property owner Murray Family Associates LLP, site address 3192, West Honda Beach Boulevard, Unit GHIJ, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail February 21, 2025, posted to the property March 6, 2025, posted to Town Hall March 7, 2025. It is the town's motion to confirm the fine of $32,600.
Case number 8359, property located at 3192 West Hollandale Beach Boulevard. Is anyone here on this case? Seeing or hearing no one come forward? Based on the testimony and evidence presented, there is substantial and competent evidence to confirm the fine. To date, the property remains out of compliance. The fines are hereby confirmed. The respondent is still under an order to comply and correct the violations. Failure to correct the violations and come into compliance shall result in the continued daily accrual of the per diem fine. Respondent is also assessed $100 administrative cost for today's hearing. Next case.
Next case is on section 8.9. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8397. Property owner Timely Property Inc., site address 3001 West Honda Beach Boulevard, Unit 312, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail February 21, 2025, posted to the property March 6, 2025, posted to Town Hall March 7, 2025. It is the town's motion to confirm the fine of $40,100.
Case number 8397, property located at 3001 West Hollandale Beach Boulevard, number 312. Is anyone here on that case? Seeing or hearing no one come forward? Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. To date, the property remains out of compliance. The respondent is still under a continued order to comply and correct the violation. Failure to correct the violation and come into compliance will result in the continued daily accrual of the per diem fine. The respondent is also assessed $100 administrative cost for today's hearing. Next case.
Next case on section 8.10. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8403. Property owner Timely Property Inc., site address 3001 West Hollandale Beach Boulevard, Pembroke Park, Florida, Unit 313. A notice of hearing to confirm fine was sent by certified mail February 21, 2025, posted to the property March 6, 2025, and Town Hall March 7, 2025. It is the town's motion to confirm the fine of $40,100.
Case number 8403, property located at 3001 West Hollandale Beach Boulevard, number 313. Is anyone here on this case? Seeing or hearing no one come forward? Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. To date, the property remains out of compliance. The fines are hereby confirmed. The respondent is still under an order to comply and correct the violations. Failure to correct the violation and come into compliance shall result in the continued daily accrual of the per diem fine. Until such time as the property is in compliance, respondent is assessed $100 in administrative costs for today's hearing. Next case.
Next case on section 10.2. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8441. Property owner Luis Quinones, site address 3140 West Honda Beach Boulevard, Lot 17, Pembroke Park, Florida. A notice of hearing to extend time was requested on February 19, 2025. It was sent by certified mail February 18. Yeah, it was sent by certified mail February 18, 2025, posted to the property March 6, 2025, and Town Hall March 7, 2025. Let me see when it was actually requested. It was requested February 3rd, 2025.
Okay, February 3rd. I signed those two. You're welcome.
It is the town's motion to give 90 days, a per diem $100 and a $100 admin fee, and this is the final extension for the respondent.
And I'll put that on the record for clarity. Are amending the final order?
Yes.
Okay. Case number 8441, property located at 3140 West Hollandale Beach Boulevard, Lot 17. Is anyone here on this case? Seeing or hearing no one come forward, based on the testimony and evidence presented, this is at the request of the respondent to the town requesting a extension. The town is recommending an extension of 90 days with a $100 per day daily fine. The magistrate will grant the request for the extension. This is the last and final extension for this case for this property owner. The property owner, based on the testimony and evidence presented, there is substantial and competent evidence to support the extension. The extension is granted. Respondent must come into compliance within 90 days or face a per diem fine of $100 a day. That amount shall continue to accrue until such time as the property is in compliance. The respondent is also assessed $100 in administrative costs for today's hearing. Okay. 90 and 100. And this is final. Let the record reflect, I wrote in final based on the recommendation and oral pronouncement. And I think that concludes.
And that concludes all my cases.
Okay, the time is 12:36. We stand adjourned. And I think I have 2 more to sign. Okay. Just a signature, right? Okay.